Under compelling circumstances, I am mentioning a matter, my lord. 270, my lord, 2 days lease, my lord. Upgraded matter, but very urgent matter. My lord, kindly accommodate my any date, my lord.
What is the urgency?
As my lord, the election is, my lord, going to held a very urgent matter. Mohammed Society case, my lord.
Which society?
Election of the Mohammed Society of India. The election matter, my lord.
Yes.
Kindly see, my lord. Kindly, my lord. Fixed matter, my lord.
Why?
Election is very near my election, my lord. Month of September, my lord. First 270, my lord.
Listen, only election is there. That is not the urgency. What else can be the urgency?
Urgency, my lord. All parties.
Yes, all parties.
My lord, not participated, my lord, due to their, my lord, present bodies, my lord. They are violating the norms, my lord. They are electing, my lord. They're violating the norms. I have to satisfy your lordship, my lord. So that, my lord, I am mentioning, my lord.
No, satisfy. You have to satisfy it first. Then only it can be upgraded. Otherwise, no chance of upgradation. No, sorry. Yes.
Is permitted to seek my lord's kind leave to move a tender matter. What happened, my lord? A fresh tender has been called. Keeping this tender in abeyance, the respondents are trying to give the tender to a private respondent, my lord, who has not participated, my lord. From 15th, they will give the work order, as per my information. On 14th, 15th, my lord. That is my information, because I am continuing work. I have been issued gate pass till 15th. So, my lord, it is my presumption that on the next date they will give them. So, my lord, 14th, may I move? I will.
All right, 14th. Serve notice.
My lord, may I be permitted to mention a matter, my lord. An application under section 14 is pending before the district magistrate, my lord. This is an application just to dispose of the application before the district magistrate. That's all, my lord.
When was it filed?
My lord, in the year 23 or 24. We have 3 applications, 3 mentioning notices, my lord, of like nature, my lord.
No, but then why are you coming today? Why did you not come on the day when mentionings were allowed?
Lord, it will not even take 2 or 3 minutes, my lord, for disposal of the applications.
Absolutely, but then I will not allow, because there may be similar other matters and I'm not allowed.
Also, kindly allowed to mention for non-prosecution.
Give.
This matter was filed in the year 2024. Urgently, that lordship, the petitioner has not received a deed which has been registered in 2015, and now it's 2025. He has not received.
10 years. What were you doing?
I have filed we have approached the registry office for several times.
Where is the matter?
For inclusion law. I'm paying for it.
No, sorry, do not. Today is not the date for inclusion.
May I be permitted to mention a matter, Lordship? My lord,
Come, your lordship, my lord, here the chief technical officer of the East Kolkata Wetland Management Authority in several occasions, my lord, issued stop work notice and then showcase notice, then restore in its own position notice has been given to the respondent number 12, and respondent number 12 is a promoter by my lord, as an urgent basis, as your lordship, any date, because construction is going on in full swing, by my lord, without my lord obeying any order, any of the notice, my lord, G+5 building, my lord, has been constructed by filling up the water body.
And G+5 body was not constructed in a day. It took some time.
Already G+3, my lord, on 23rd 7 2025 OT notice has been issued by the chief technical officer that restored in its own position, my lord, that is avoiding that notice. Construction is going on, my lord, any date as
very well. Thursday it will appear.
My lord, may I allowed to, my lord, mention a matter, my lord?
Yes.
Upgradation, my lord. This matter, my lord, pertains to, my lord, my clients have registered a property in the year 1996.
What do you want?
Upgradation, my lord.
No, sorry, today is not the date.
With your lordship's leave, if I may mention, your lordship, this matter is appearing in the hearing matters. I understand that your lordship has said that no hearing matters, and every Friday they are appearing. Your lordship, under very compelling circumstances, on every Friday, the situation what usually happens is that there's a resolution, your lordship, that has nothing to do with your lordship. But your lordship, the issue which we are facing is 8 bank accounts have been closed since 2022. And the proceedings are very well going on, your lordship. The pleadings are completed, but your lordship, 8 bank accounts are closed by the PMLA, your lordship, on a very irregular basis, your lordship. I understand with your lordship that your lordship does not want to take hearing matters, but it's a very small issue and it pertains to 8 bank accounts of people.
What is the item number?
Your lordship, it's appearing as 1774 to 1781 in the hearing matters from past 3 months, your lordship.
1774 to 1781,
your lordship.
Do not hand over slip. Friday, next working Friday is 22nd. 22nd hearing.
Obliged.
May I have your kind permission to mention a matter, Lord?
1401.
Yes.
My lord, it's my land, your lordship. We found
No,
that.
but then what are you mentioning today?
I couldn't do it on the last occasion.
You have to get it done when it is taken
It's
up.
very urgent in the sense, your lordship. It's very urgent.
Very urgent, then you should have come. See, the court has fixed a day. Please do not.
This is item 66 of my lord's appellate side list, my lord.
Yes.
Pending the writ petition was taken up for consideration already once. Pending adjudication, my lord, a possession notice has been issued last Thursday evening. We approached my lord on Friday. My lord was of the opinion to come back on Monday. We are
Yes.
approaching my lord on Monday. The issue is, my lord, they are
But whatever the issue, did
they are
you
well
file an
entitled.
application?
My lord,
Did you file an
my
application?
lord, it is written up, it is already running in the list. And my lord,
The new
repossession.
fact, the new fact, will you not bring it on record?
Sir, but my lord, the repossession date has been given on 12th. That is tomorrow, my lord.
Yes.
By the time I file an application and my lord, it is made returnable, my lord. I will they are, my lord, entitled to do whatever in due process of law. But the issue was, my lord, they had not adjusted whatever amount I have paid to them.
This
is
will
item
appear in the
66.
list tomorrow.
I'm so grateful.
My lord, may I have your lordship's kind leave, my lord, to mention item number 1797 of your lordship's list of August 2025, where I indicate the urgency. I am the
Do not indicate. Come when next upgradations are taken up.
my lord, the only difficulty is, my lord, I am the developer. I am maintaining the entire premises as on date 72 lakhs is due.
Last Monday, the same urgency was there.
No, I am mentioning this for the first time.
Exactly. Last Monday, the same urgency was there.
Yes.
And all matters regarding upgradation, no questions asked, upgraded. Today, nothing will be done.
May I be permitted to mention one matter, one application for inclusion, my lord. I have mentioned the earlier,
No.
my lord.
If you have mentioned, then it will appear. Please do not mention.
Lordship, on 8th August, Mr. Kormukar had mentioned a matter which your lordship had allowed your lordship and kept it returnable on Thursday, your lordship. In same writ petition, your lordship, I have filed an application for addition of party, your lordship. I am saying that the application be taken up on the same day, your lordship.
Give the number. দেখুন
have lordship-
প্রতিবার আসার কথা আছে বলছে।
May I have lordship kind leave
Yes.
to mention, my lord, this matter, my lord, payment of dues, I found, my lord, in July, it was on heading. There was a heading of payment of dues. My client also in the same positions, my lord. It is pending, my lord, since 2023. My lord, this is not in the list.
So payment of dues.
Dues
What
with regard to, my lord, the tenders that has been completion certificate issued, more than 43 lakhs. Part of the payment has been paid 2022. Then
Alright.
more than 43 lakhs is paid.
Item number?
Well, this is not appearing, my lord. This.
Why did you not mention?
I
When
was,
in
my lord, I was ill, my lord, I sick, my lord, I could not, my lord.
Then it
That's-
cannot be done.
Right.
Next month come.
My lord, next month, my lord, any day, my
Please
lord, your
come
lordship-
next month. Yes.
Hello, may I beg your lordship for upgradation the matter?
Sorry, no upgradation.
Malo, let me finish. One second.
No
One second.
upgradation, please.
Malo, today the bank is trying to take physical possession. If physical possession is taken, we'll be out of residence.
Yes.
We'll be thrown in the state.
Yes.
That today itself they have threatened that today physical possession will be taken up. The matters are appearing in a lawsuit list under item number 323. I am begging to safeguard the interests of the of your petitioner to take up any day upgradation. Otherwise, my client will be out of residence and he will be thrown to the state. They have already
What
threatened.
was the writ petition for? What was the prayer in the writ
Petition
petition?
challenging against the RBI action.
RBI?
RBI action.
What did RBI do?
RBI will do. Initially, the bank has requested us for placing one-time settlement proposal. We have filed one-time settlement proposal, and during the one-time settlement
What
proposal,
has RBI got to do with it?
yes, I'll explain. Madam, kindly bear for a moment. I'll explain what the role of the RBI. Against the RBI, you have come here. The fact of the case, during the OTS proposal, petitioner failed, and accordingly, he couldn't comply with the RBI OTS proposal. For 15 days, we have asked for extension of OTS proposal. They have not done that. Accordingly, we have gone to the RBI for considering the game. That's because the RBI has framed the OTS proposal and he has to report, the bank has to report the RBI. RBI, while the complaint was pending before the RBI, they have taken step according to their own sweet will And RBI, during the pendency of this petition, RBI has closed the case. So against the RBI action, I have come here.
Very
Nothing.
RBI action we will see, and let you go out of possession. All right. You will be thrown out of possession. RBI is not throwing you out.
No, RBI is not considered because RBI has
If
framed
the
the
court has
guideline.
followed the submission, it doesn't take so much to make the court understand what your problem is. All right.
Yes.
Thursday it will appear.
Yes, I'm grateful. I'm grateful.
In the meantime, you will be in the streets.
Yes, yes. I'm
Item.
grateful. I'm extremely
Yes,
grateful.
yes. And give notice.
Yes,
If
I
your other
must give
side is
notice.
not
I must give notice. I have
Again,
challenged the
what is
RBI
the item number?
Item number 323.
Of
232 of monthlies. 232. I'm grateful, my lord.
Lordship's kind leave to mention one matter. Lordship was pleased to dispose of this matter by an order dated 6th August. The order has not been uploaded yet. Lordship.
6. It will be uploaded today itself. Don't worry.
May I have your lordship's kind leave, my lord, to mention a matter, my lord, for upgradation, my lord. This is appearing as item number, my lord, 66, my lord. Remembers, my lord, this matter, my lord, pertains, my lord, to my lord, upgradation of date of birth certificate, date of birth of, my lord, the petitioner in Aadhaar card, my lord, because of which, my lord, the bank account is not being updated, and, my lord, it is going to be freeze, my lord. That, my lord, petitioner is, my lord, a poor lady, my lord, who makes a living by selling, my lord, these collar bands, my lord, to my lord, the advocate.
What is the item number?
My lord, item 66, my lord. Every week, my lord is hearing, my lord. It was supposed to appear today, my lord. It is appearing today, my lord, but at 66, my lord. My lord, Aadhaar authorities, my lord, they were praying time to bring instructions, my lord. Lord, twice authorized, my lord, this matter has been taken up, my lord. Lord, item 66 of today's list, my lord.
Last part, one matter.
Yes,
In case it is not taken up today, tomorrow it will be upgraded.
Regarding item number 1721, my lord, I am a senior citizen, my lord. My husband, my son.
Why are you mentioning today?
Because, my lord, very urgent matter. Because, my lord,
No urgency.
my son, my lord, died, my lord. I am not paying, my lord, any amount, my lord, regarding, my lord, insurance, my lord.
Nothing
This is
doing.
matter, my lord, bread and butter. Kindly take
Bread
it
and
up, my lord.
butter last week mentioning was
I am senior
accepted.
citizen. Kindly
I
take it up.
cannot help because there are so many matters.
I know,
They
you will have
had
patience.
drifted thereafter.
Kindly taking up any date, my lord, any date. Kindly
Not
take it.
possible.
May I permit to mention, my lord, under section 14 of Foreigners Act, I am languishing in jail for more than 100 days, my lord. I have been labelled as Pakistan national, my lord, for upgradation, my lord. Monthly item number 1527.
Not upgradation.
May I
Upgradation.
kindly be
My lord, kindly at any day, my lord.
Today is not the day.
My
Do
lord.
not mention.
May I kindly be permitted to mention, my lord, one passport matter, my lord.
What does passport matter mean? There are so many passport matters.
Passport respondent authority, my lord, has not.
No, is it there in the list?
Yes, my lord.
Nothing doing.
My lord.
Yes.
My lord, my senior is mentioning through
Yes,
online.
please.
Millards, may I have your kind permission to mention a matter, Millards? Millards, it's a writ petition we filed against the Competition Commission of India.
Where is the matter?
My lords, the matter I am requesting for listing on Wednesday, my lords. I will come down from Delhi for the matter. Lordship, the urgency in the matter is this, my lords, that a supplementary DG report has been filed by the Competition Commission of India without permitting me cross-examination, which is specifically provided for under Section 41 of the Competition Act. They have not followed procedure, my lords, and steps are to be taken against me from the 15th onwards. The deadline expires on the 15th. They've just given me 1 week's time to do this, my lords. There is grave urgency in the matter.
Where is the matter?
My lord,
Is
we have
it
filed the
there?
matter on Friday. My lord, we have filed on the matter on Friday. My lord, in presentation form, we have put the date of 13th. I am
All
praying
right.
for the appearing as a new motion and at the top of the board, my lord, so that the matter can be heard. We are praying for that only. On 13th.
That's all, my lords.
13th, the matter will appear in the list. If that is the due date, it will appear in the list. But then when it will be taken up, it has to be seen.
There is some urgency, my
I
lord.
have heard the urgency, but then
request, Lordship, may I only pray, Lordship? Millards, I'll come down myself for the matter from Delhi. Millards, may
thing
I
is, you are not required to come down. The court accepts virtual hearing. You
I'm
can
aware,
very
Millards.
well
I'm
be
aware,
online
Millards.
and the court will
No,
hear you.
Millards, it will be an honor to come to appear before this honorable court, Millards. Millards, this is also
That is
the court where I
different, but
began.
thing is, you coming down all the way from Delhi and then the matter is not taken up, this becomes very
Millards, I'll
difficult
bow
for
down, Millards.
litigants.
This is also, Millards, the court where I began my practice, Lordship. So therefore, it will be an honor to come. Millards, may I be permitted, the matter may be permitted somewhere, Millards, on top of the board on Wednesday, Millards. There is also urgency in the matter, Millards, because after 15th, Millards, they will initiate the proceedings and then this writ will become infructuous. That's my difficulty, Lordship.
Give the number.
Yes, ma'am. I'm so
Serve,
grateful. Lord.
serve notice.
Yes,
Urgent motion on Wednesday, 13th.
13th. I'm so grateful, my lords. Very
Like, I
grateful.
wanted to mention one matter, your lordship. This is MSME matter, your lordship. The Honorable
Upgradation inclusion what?
inclusion.
Today is not the day.
Oh, your lord.
I'm mentioning for upgradation item 9.
No, today is not the day. Do not mention.
I've taken out an application. It is not appearing that.
Applications appear on Thursdays. It will appear on Thursday.
Mentioning for upgradation.
No upgradation, no inclusion. Call the list, please.
There is a contempt application. I'm praying for inclusion in the list.
No, today is not the date for inclusion and upgradation.
Lordship.
Yes, please.
I appear for one of the applicants, in terms of your lordship's last order made on the 31st of July. Your lordship was kind enough to record that application for addition of party in the contempt has been filed.
Whether the applicants
have
have
a right
arrived.
of audience. That was the, my lord, I am. This is the lordship judgment, my lord, in Rowena, my lord, Nandini Meherot. There are 2025 SCC online 6031. It's now, my lord, there in the SCC online. My lord, there your lordship has been disinclined. You have been to copy there.
No, tell me what is your stand now.
My submission to your lordship is that today, in terms of your lordship's order, though your lordship has been pleased to consider J. Parihar's case here, in terms of your lordship's order, the corporation rightly wrongly has made an order. That order, in content perhaps cannot be a subject matter of challenge. That is one. If it has to be challenged, it has to be challenged by an independent proceeding.
Connection.
Then, the second thing is, apart from anything else, that order has taken into consideration the FAR, and has laid down the order, which is the order passed by the SOP. One aspect of my learned friend's submission is that the executive engineer was directed and not the special officer building. That is one aspect of the matter. The special officer building records that this building stands on Chittaranjan Avenue. Not Chittaranjan,
whatever is the road.
On Avenue,
whatever.
The wide road. So considering the FAR, and it is a permissible construction, that is what has been held. It is not something, which transgresses, the corporation rules, and Rule 62 of the building rules have been relied on by the SOP. Now, apart from anything else, though your lordship has been pleased to hold in Rowena that the beneficiary of the order cannot be heard in a contempt matter, it would widen the scope of the litigation and everything. Despite that, I will be humbly beseeching your lordship, kindly allow my application for addition of party. Can ask them to serve a copy of the contempt application. We shall make our submissions on the basis of the.
Yes.
Now, this is Rowena's judgment. I can have.
No,
I'm for the petitioner. My lord, this was your lordship's last order.
No, I have the copy of the order.
Yes. So, my lord, I'll make submissions on why, my lord, my learned friend has no right of audience and should not be permitted. Lord, first and my lord, first. Yes, my lord. My lord, kindly, my lord, sees your lordship's own judgment, Rowena Nandini Mehra.
Yes, that he
Your lordship has seen paragraph. No, I'm from paragraph 29, 30. Your lordship has held that view. Now, your lordship's, my lord, direction was that to give further, my lord, get some more judgments, my lord. May I cite, my lord, 2008 SCC Online Calcutta, page 10, 2008, 2 CHN 253.
2008? 2 CHN?
2008, 2 CHN 253. Kindly see paragraph 6. Lord, kindly see, my lord. Mr. Singh and Mr. Bandyopadhyay have been heard for against the application respectively at length, assuming that the application to be maintainable. The court, however, considered it unnecessary to deal with the rival submission in extenso for the application for intervention appears to be not maintainable in view of the division bench decision of Nalini Ranjan Das versus Anup Singh, reported in 1992 CLJ 190. It has been held therein as under. The focal point for determination is whether the said application praying for intervention in contempt proceedings is maintainable or not. The Contempt of Courts Act 1971 and the rules framed by this code do not provide for intervention by third parties. The provisions of the Code of Civil Procedure as to the addition of parties do not arise in the contempt matter, which is entirely between the court and the contemner. On the question of the third party intervention, we are of the view that under the Contempt of Court Act, as also rules framed thereunder, the applicants cannot be permitted to join as interveners in the contempt proceedings. The presence of the interveners in a given situation may lead to the generation of heat as well as arming for the against the contemners with lethal weapons, which in our opinion would make the court involved more than what is necessary in exercise of its jurisdiction under the Contempt of Court Act. We are therefore of the view that applicants have no right of participation, inasmuch as the right of participation is not given under the Act to third parties, including those who act as an informer. Now, in the facts of that case, faced with this decision, Mr. Singh intended to draw a distinction by submitting that the Union of India is not a third-party intervener, but was all throughout a contesting party. This is also going to be my learned friend's case, and therefore the decision in Nalini Ranjan Das Supra would have no applicability in the case. The distinction sought to be drawn is unacceptable, since the interveners in Nalini Ranjan Das were respondents in the writ petition, although they had not contested it. But that is hardly relevant in view of the law laid down where therein extracted above. An application for intervention in a proceeding for contempt, which is entirely between the court and the alleged contemner, cannot be maintained either under the Contempt of Court Act or Civil Procedure Code. This court is bound by the said authority, and accordingly this court has no other option but to hold that the present application is not maintainable. The same stands dismissed, but without any order as to cause. But clear, unequivocal law has been laid down. Following a division bench judgment, which, my lord, was binding on Justice Dotto.
Yes.
And my lord,
Only one humble submission, my lord, with respect to the GN.
Who are you?
My lord, I am the applicant in GA2. My lord,
Same,
no,
you stand in the same footing.
I was not a party in the audit petition. Now, what happened that thereafter, against me, they do not have any allegation. Only thing that in this order, a right has been incurred upon me by which the SOP has directed me to pay the regularization charge for commercial usage. That is the only aspect of my lordship. If my lord kindly directs them to accept my
No, in his contempt matter, the court will pass direction upon the corporation to accept your charges.
Because my lord, if my lord touches the order, my lord, if the order sets aside, my lord, then I will be suffering, my lord.
as I also argued
they
on the
do not
last
have any
occasion, there
allegation
cannot be
against me.
vested right in an illegal order.
My lord, they
Or, my lord,
cannot-
order that is passed
That
in
is not an
contempt
illegal
of
order. With
Yes.
Lord,
Application cannot be heard. All right, come.
my lord,
I'll-
kindly protects my right, my lord. That's the only. That is because if my lord,
Yes. Nobody can
Because
claim that there
against
is vested right.
Reply, my lord, only one submission.
GA 1 and 2, yes.
My lord, kindly permit me to at least say this. Your lordship is not inclined to accept my intervention application.
The
My lord,
law is such, what can the
my
court
lord,
do?
the thing is, my lord, one thing is, my lord, an order passed in terms of your lordship's order may be a good order or a bad order. My lord, it may be a subject matter of a fresh proceedings, not in contempt, where, my lord, the order may be assailed and where I may be heard. My lord, today kindly look at the position. It is not contumacious inaction which is complained of. It is alleged that, my lord, in contempt jurisdiction, what is being sought to be argued is that the order made by the alleged contemptor, my lord, is unjustified. And, my lord, in order to establish, my lord, justiciability to this order.
Possibly I have given reasoning
Exactly.
in
Here,
this,
here your lordship
why
has covered.
the court has
Correct,
entered
correct.
and the court
No, I
will
agree.
not hear.
No, the same thing was here in Rohina. And, my lord, your lordship has been kind enough to also lay down the law that illegal construction and everything, my lord, your lordship has relied on, my lord,
Maybe in
various-
other matters the court can permit or something can
Only this
happen,
much.
but what has
this much, my lord, kindly visualize. Today, your lordship is looking at an order made by the corporation in a proceeding arising out of my lord's order. Because my lord was first, my lord, kind enough to relegate the matter to the corporation authorities for a decision. One limb of submission of the petitioners is that the executive engineer should not have acted, it should have been done by the SOP. On merits of the order, if your lordship is examining the merits at the instance of a contempt petitioner, and restricting the issue only between the contempt petitioner and the contemptor, and not the parties who are beneficiaries in the light of my lord's judgment, then that order does not become subject. Your lordship may not subject to correction. Perhaps your lordship will not be persuaded to quash the order. If it has to be quashed, the second order, it has to be.
Let us see what is to be done. To the two applications are there.
Only thing, Milord, in GA2, Milord.
GA1 and GA2.
Milord, only one thing, Milord. Milord, they do not have any allegation against me, Milord. My order,
Not-
naturally. How are you?
May not have.
But if my lord is setting aside the order, that will that will infringe my right.
Let us see what to do. Today applications are there. I am dismissing the applications. What will happen to the contempt? The corporation is here. The contemptor is here. The court will deal with the contemptor. You go out. Thereafter, what happens is with the contemptor and the court. Do you get it? Achha, GA1 and 2. Both the applications have been filed seeking intervention in the contempt proceeding. Stop. The applicants allege that if the court interferes with the order that has been passed by the contemptor, then the rights of the applicants will be infringed. Stop. The contemptors intend to make submission in support of the order that has been passed by the contemptor, allegedly in compliance of the direction passed by the court. Stop. On the last occasion, the court framed an issue as to whether the applicants have a right of audience in the contempt proceeding. Stop. Paragraph. The judgment delivered by this court in the matter of Tandon Brothers versus Rajesh Pandey and another spelling, reported in such and such, clearly lays down that took note of the order passed by the Honorable Division Bench of this court in reported in such and such, and clearly laid down that the applicants do not have any right of participation in a contempt proceeding. Stop. The Contempt of Courts Act, 1971, and the rules framed thereunder. Rules framed by this court do not provide for intervention by third parties. Stop. The provisions of the Code of Civil Procedure as to addition of parties do not arise in the contempt matter, which is entirely between the court and the contemptor. Paragraph. In view of such authoritative pronouncements, the court is convinced that no opportunity of hearing can be given to the applicants in the contempt proceeding. Stop. The application for addition of party accordingly fails and stands dismissed.
GA1.
Both 1 and 2. When is the contempt appearing? Who is the contempt? Yes, what will happen to the contempt now?
Your Lordship will kindly see your Lordship's order in respect of which this contempt application has been drawn up. Well, the executioner was directed to deal with the matter. Now, he thought that he has to process the file And according to the circular issued by the higher authorities, they have to send the file to the appropriate authority. I have already given 2 circulars before your lordship, my lord. And he has dealt with the file, processed the file, and sent to the higher authorities, wherefrom it was sent to the special officer building, and accordingly thereafter whatever process has been followed, my lord. Now, my lord,
Assuming
yes,
that the executive engineer, he decided it in his own way, though in this Roina that has also been considered that own manner of consideration or interpretation is not cannot save the person from the contempt. But then assuming that to be one of the explanation of the contemptor in not dealing with in his own way and referring it to somebody, even then the order impugned is contrary to the provisions of law.
no, my lord,
Is it not?
I am not. I am not. Your lordship was in all various matters. While sitting in courtroom number 24, your lordship passed order directing the executioner or DG building to hear and decide the matter. Hear and decide the what was not there. To direct it to deal
What
with
is
the
the
matter.
What is the unauthorized construction? The nature of unauthorized construction,
There is
which
one,
has been regularized?
that one floor above the 6th floor.
I am not hearing
Because
you, Mr. Bhattacharya. Both
that
of
was,
you, no.
that was within the affair, within the permissible affair. That has been
But various major transgression. It's not, but the circular your lordship has seen only minor. Here, my lord, major unauthorized construction has been sought to be regularized, lock, stock, barrel.
SOB orderটা আছে।
হ্যাঁ ওটাই দেখছি না এখানে নেই পরে আছে SOB orderটা kindly seize the order.
Parking spaces
Mother, kindly see the,
being, yes, I am there at the same page.
yes, mother. This one the
See the parking spaces being used for
numbers less. I have seen it, mother.
My lord, kindly see from paragraph 3 onwards of the report.
Yes.
Kindly see one toilet such and such
If you are within
has
within
constructed
the limit, if you are not valid,
has constructed at side
if you are
open
within the
space
limit.
beyond sanctioned regulation plan such and such. Then 4 tenement area at first floor southern side has converted from residential to institutional. Now occupied by NKG Diagnosis beyond sanctioned regulation plan being such and such is
But
done.
only rule 62,
Then
70, 78. Hey, rule 62 and 78 has been violated.
No, but I am just reading out
Rule
the main
62 and
report.
78.
Then he has obtained in paragraph 5 tenement area at first floor northern side was converted from residential
That
to
is the report,
assembly.
not the order.
Correct.
The reportটা আমি দেখছি
As a ceremony.
Where are you reading
Not the main
from?
report. Main report.
report annexing the order.
You know, that really summarizes to your lordship for
Yes.
easy understanding. My lord, kindly see 3,
Hmm.
4, 5. All, my lord, grave and my lord, major my lord, deviations. Then 6. One tenement area occupied by Virendra Kaur and others and one room are constructed at 6th floor beyond sanctioned regulation plan of KMC building such and such. During inspection, it was also observed that the tenement area of 64 square meter at 6th floor is already occupied condition and the occupiers are claimed that they are residents as tenants in the said premises. So separate room constructed on the 6th floor without sanction whatsoever.
That is within FAR.
Maybe sanctioned height
What
building.
is the use of a sanction plan? Please
But
tell
I am
me.
telling you, Lordship, but there is some
There is
difference between illegal construction and unauthorized construction. But illegal construction which means that which violates the rules. Unauthorized is which has been done without authorization. Now, my lord, there are many unauthorized construction. If it is within the rules, corporation will normally allow it. Now, in this case, the room on the roof, which comes within the ambit of the affair, with the permissible ambit of the affair, accordingly it was allowed. Though whether the person who has allowed, he has jurisdiction or not in terms of your lordship's order, that is a different issue. Now, so far the violation is concerned, your lordship will find so far building rules, only rule 62 and 78 has been violated. From the order of the special officer, it reveals. And there are other violation is Rule 41, section 416. This is the basic violation. But the room on the roof, if it comes within the ambit of the building rules, corporation has to allow it.
Has to allow. Very well. But kindly see, your lordship.
Normally, if a person makes an unauthorized construction, maintaining the building rules, which if he applies, he would get it.
This matter, possibly I will close it here only. Please come.
Will hear me.
Kindly consider my statement that the executive engineer was not in sheer content, my lord. He has misunderstood the order.
That is also contempt. This
No,
Movina Supreme Court has taken into this submission. Misreading will not save contempt.
The word deal.
But then I'm not going to that extent.
And despite, my lord, several letters being written to them, he could have approached your lordship for a clarification. That he has not done.
Peruse the report filed by the executive engineer. Building department. It's Boro 2 or 4 or what? Boro?
It is Boro
2.
Boro 2.
Aye.
Not one very important aspect. He has only, my lord, not allowed regularization of my portion, the petitioner. Rest, everything has been regularized. That also will show how, with a closed mind, he has acted.
Stop. It appears that the executive engineer has forwarded the entire file to the special officer within bracket building to deal with the unauthorized construction stuff. The special officer building has passed an order, and special officer building has passed an order on 16th April 2025. Stuff. The petitioner is aggrieved by the same stuff. The court is of the opinion that the petitioner ought to approach the competent forum challenging the said order. Stuff. It does not appear that there has been any willful or intentional violation of the order passed by the court. Stuff. In view of the above, the contempt application stands disposed of. It will be open for the petitioner to approach the competent forum for further relief if so advised.
My lord did not call upon me, my lord. I could have showed, my lord, this order is absolutely, my lord.
No, that possibly cannot be done in the contempt.
My lord, he has tried to overreach your lordship's directions.
Yes,
by
next.
passing the order.
Next one, please.
He has penalized me and he has been completely given a clean chit to the private respondents.
My lord, this matter pursuant to my lord's order direction, demolition proceeding has been initiated and some order has been passed. But the demolition proceeding has not yet been completed. I need some time, my lord.
I'm for the petition, my lord.
15th April 2024, the order was passed.
For 16 weeks, my lord.
16 weeks?
Yes, my lord.
May, June, it is over.
August.
Now it is August 25. More than 1 year has elapsed.
And there some order has been passed to submit there.
Supposed to be filed today,
Not ready, not complied. It is as simple as this.
Some more time.
Please come.
My lord, on the last occasion, my lord, what they did was, well, this was a kind of order which was circulated
On 15th of July.
on 15th of July, just after the day of, my lord,
Past order. Yes.
no whisper that the 2 floors are illegal. They're asking for a structural report from us. No mention about what is the sanction plan. The corporation has to give their own sanction plan to that person. A travesty of justice, my lord. They're siding the persons.
See, all the descriptions that have been mentioned over here shows infringes. All. Even thereafter, corporation goes on to regularize. What is this? The corporation is so cash trapped. They continuously require money for all these regularizations. Huh?
Saying 60-year-old building, 2 extra floors.
Now this is going to collapse and then some casualty will happen. As the interim order was passed on 19th of September 24.
No order.
So this is the order. 9th of June 25.
9th of June 25.
It was communicated after the court's order was passed.
Hearing was on 18th March, 19th March.
Yes. So in that case, you have to challenge this. Please come. Ki bolna? Guru hai nahi to? Learned advocate for the petitioner produces before this court copy of the order dated 9th June 2025 passed by the Special Officer Building, allegedly in compliance of the direction passed by the court. Step. Paragraph. The petitioner is aggrieved by the same. Step. It will be open for the petitioner to approach the competent forum for relief, if so advised. Contempt application stands disposed of. Next.
Make please, your lordship. Director on behalf of the petitioner, my lord, pertaining to, my lord, the decision of the speaker to
Is the AG there?
The London AG is not available today, your lordship.
Not
He has
available?
come. He has not come.
It is continuing possibly since the past.
Yes.
Yeah,
Whenever the matter is taken up, why don't you take the instruction?
Your lordship, I have three leaders on top of me, your lordship.
So let somebody make submission.
Your lordship,
Number of leaders doesn't help. The matter gets adjourned.
your lordship, would your lordship be pleased to keep it on Wednesday? I will have the instructions. I will at least
Continuing, my lord, at the instance of, my lord, the matter was being heard, my lord, on
Please
merits,
come.
my lord. My lord, kindly, my lord, hear it out on merits, my lord.
The learned advocate appearing on behalf of the state respondent.
No, for the speaker.
As a speaker seeks adjournment for the day. Stop. Prayer has been made to post the matter on 13th. Stop. On such prayer, post the matter on 13th. Stop. Learned advocate representing the speaker shall come ready with proper instruction.
Wait.
Next.
Number 4. My lord.
Similar circumstance, I
Matter
believe, my
also,
lord.
your lordship, I'm pretty handicapped.
My lord, it's the same situation, my lord.
Same
My lord,
situation,
may I
my
pray for a small indulgence if your lordship be pleased to fix a date so that he can appraise and
Same order over here.
Budhvar.
5.
Budhvar.
My lord, I am for the petition.
My lord, my senior, Mr. Maynak Bose, is appearing for respondent number 2, my lord. He's feeling bit under the weather, my lord. Kindly make it not today.
Who is appearing?
Maynak Bose, sir. Senior advocate Maynak Bose, sir.
My lord, this is the matter where this arbitration proceedings, my lord, the MSME arbitration. Mr. Shakko Sen has
Yes,
concluded
yes,
his
yes,
argument.
yes, right.
I think Mr. Bose is not with.
Yes. Right. Learned advocate representing. Who is he representing?
Mr. Maynak Bose.
Who is he representing?
Respondent number 2. Respondent number 2. Respondent number 2.
For the respondent number 2. Seeks accommodation. Stop. Next Monday, 18th. None for the parties. List 8th September. Same order.
Well, at 8, I appear for the petitioner.
Lordship, 8, I appear for respondent number 225.
My lord, I'm supposed to file my affidavit in reply. My lord, it is ready, my lord.
Where do you start? It will
Yeah.
come in the meantime.
My lord, kindly sees, my lord. There was an interim order which was passed in my favor. My lord, order dated, your lordship kindly sees. My lord, 9 July 2024, the first interim order.
Yes.
Achha, 2 to 5, yes. My lord kindly sees an interim order was granted. My lord kindly reads from the page 2, second paragraph.
What is the date?
Oh, my lord, 9th of July 2024.
In this matter?
Yes, your lordship. Item 8, Intex Safety Private Limited versus Union of India.
I can get orders from August.
9th of 6th of August, your lordship has
Yes,
got.
yes, 6th
No,
of August.
my lord, that was an order wherein they have filed a vacating application for vacating of my interim order of 9 July. So that vacating application was also dismissed. They preferred a appeal, wherein, my lord, the interim order was confirmed, appeal was dismissed. Now the point which is being jotted down before your lordship is that only to the extent whether the expired bank guarantee which is in their custody, whether that expired bank guarantee should be returned to the writ petitioner or not, to that extent, which has been, my lord, affirmed by the honorable division bench already. Your lordship, I'll take your lordship to that. Your lordship kindly sees this order, 9th of July 2024, the first order. Original test check.
এখানে
My lord, may I
থাকবে না
file my affidavit in reply, ma'am?
এখানে থাকবে না কেন অর্ডারটা?
এটা কি? Affidavit, competence. May I file my affidavit in reply along with the changed wakalatnama, my lord, and the competency, my lord? Department. Achha, competency of department. Your lordship kindly sees the 9th July order. Dilam, apni ra joseph pe dilam.
The tendering authority on other instructed the encashment.
My lord, the kindly sees, my lord, the bank has opted for the, my lord, invocation of the respondent number 2 to 5 has opted for the invocation of the bank guarantee, which, my lord, we have prayed for stay in the instant writ petition.
Petitioner is an unsuccessful bidder.
Yes.
Lordship, they were
My lord,
unsuccessful bidder, but the problem is that
They
they filed certain documents which were not in order and which were in derogation of the bid conditions, and therefore that violated the bid conditions and which would lead to the
No, he
encashment of the bank.
cancelled the bid.
Yes.
Lordship, but these were very serious violations of the bid conditions,
has
and
to
they are in violation of gym
examined on
conditions
trial.
also.
And prior
Lordship,
to that, my lord,
Lordship, they are in serious derogation of the bid condition in the sense that they are submitted lots of false declarations, which were, I mean, they had to procure a certificate from experience certificate. So they
relied upon false and fake documents.
Yes, your lordship.
Once.
Yes, your lordship.
Cancel the guarantee.
Yes,
The bid that has
no, it has been awarded to another person.
All right.
Successful
Because he relied upon false documents.
Yes, your lordship.
no,
Right.
not for that. Your
Lordship,
That is
those
for
false
whatever.
documents, it has been certified from the embassy of Ukraine also that
All right.
that
All said and done, he is the unsuccessful bidder. Why don't you return? And moreover, it has lapsed in the meantime.
Yes.
Lordship, there are certain judgments which say that the bank guarantee can be there can be restoration of the bank guarantee.
Here there is no scope after the affirmation by the honorable division bench.
In the facts and circumstances of the case, is there any chance? No.
Lordship, they are not the successful bidder.
That is the reason. Exactly
My
the
lord,
reason. Where is the bank guarantee?
It's
Lordship,
in their custody only.
Please return it.
Lordship,
My lord, an
Lordship,
acting
may
to the
kindly
GM
grant
portal
that-
wherein the tender was floated, within 15 days of the selection of the successful bidder, the bank guarantee has to be returned. And that long back expired. Amar bigta down.
Show me the tender.
My lord.
Notice inviting tender regarding return of the bank guarantee to unsuccessful.
Yes, my lord, may I? My lord, kindly sees. My lord, 15 days का क्लोज कहाँ पे? My lord, kindly comes to page 93 once.
Lordship, apart from that, there are certain other judgments which want to, in the respect of the fact that they cannot invoke the jurisdiction of this court also.
My lord, 93.
Because
That has gone to the division bench. The court has affirmed the order. Now you say the court doesn't have determination.
the
What
court
is
did
it?
not deal with that point.
My lord, kindly
This
see
money of
page
success shall be
93.
returned within 15 days
OP,
after the
P1.
award of contract or expiry of the bid validity, whichever. However, in case of 2 packets with securities, technical degree. So this was by way of an earnest money deposit.
Yes.
EMD.
Yes, and the whole tender was floated through this GEM portal.
Yes.
It's the government portal, my lord. And the government portal says that once the bid has been given to the successful bidder, my lord, thereafter the unsuccessful bidder's earnest money deposit has to be returned within 15 days. So, my lord, that 15 days, your lordship expired, my lord, on 8th March 2024. And my lord, their first invocation letter was on 26th March 2024, which was turned down by the bank because of the reason that because it was a conditional bank guarantee, my lord. There are 2 conditions which needs to be fulfilled. And there was no mentioning by the SCCL authority for those violation of those, my lord, conditions. My lord, the second invocation letter was after 3 months, 15th of June 2024. That was also without any reasons. Bank again turned it down. Challenging that second invocation notice dated 15 June 2024, we approached this Honorable High Court and we, my lord, secured the interim order. Thereafter, kindly seize your lordship the third invocation notice on 9th of July 2024. Yes, 9th of July 2024 at page 21 of the affidavit in opposition as filed by the bank. Your lordship will see for the first time after 4 months.
Opposition ache? Filed by the...
After 4 months of the expiry of the bid, my lord, they have written the third invocation notice, which my lord, till by that time, my lord, we obtained the interim order. So bank replied to them that as there was an interim order, it cannot be, my lord, encashed. Good.
ব্যাংক গ্যারান্টি কষ্ট করে এখানে নোটে লেখা রয়েছে অপোজিশন দেখ নোটে লেখা রয়েছে দেখ
ব্যাংক গ্যারান্টি ল্যাপস করেছো কবে?
রিটমিশন দেখ
Bank guarantee lapsed on 12th of July 2024.
Yes.
So, your lordship, this is the third invocation notice on 9th of July after 4 months of expiry, my lord, of the bid value, and my lord, after the last date of 15 days, which expired on, my lord, 8th of March 2024, by which time they are supposed to return the original bank guarantee to us, which they did not, chose not to, and pressurized us, my lord, for extending the bank guarantee once again. We have written several communications to them for returning of the bank guarantee as we became unsuccessful bidder. We became the L2 bidder. My lord, thereafter, my lord,
Suppose they do not return the bank guarantee to you now.
Right.
The guarantee has lapsed.
Lapsed.
What will be the effect of the guarantee?
My lord, nothing. Only, my lord, my retention money is lying with the bank, which I will not get returned.
How much is the retention?
My lord, I think it's 5 lakhs. For 50 lakhs, it is 5 lakhs.
All right.
10% of the bank guarantee amount. So that is lying with my bank. For them, for not returning that bank guarantee to me, I cannot produce it before the bank for encashing my 5 lakhs of retention money. That is the only difficulty.
My lord, first I want to start with saying, merely because the bank guarantee has expired, that does not mean that so far as the claim made by the petitioner is concerned, that has become infructuous, or vice versa, that I cannot, my lord, have any say on this. But if I am successful, if I am successful either in dismissing the writ application, I show to your lordship, there is a judgment which would show that if any right was, if any by way of any interim order, they have not secured any right whatsoever. But if ultimately the suit or the writ petition dismisses, then my lord, your lordship has the power to restitute that. So my lord, first of all, so far as this interim order was obtained on 9th of July, that was obtained ex parte, against which, my lord, we have moved the learned single bench. Learned single bench was of the opinion this issue involved in the writ petition can only be decided after exchange of affidavits. Thereafter, my lord, challenging that order, my lord, I went up to my lord, honorable division bench, and honorable division bench also, my lord, without expressing anything on merits, has simply, my lord, observed that on exchange of affidavit, it has to be decided whether there was any fraud or something like that. Now, my lord, so far as my objection is concerned, first of all, my lord,
Now,
I am
this court
submitting.
cannot decide fraud.
No, my lord, kindly, but prima facie case, your lordship cannot decide prima facie case. Your lordship can decide whether my invocation on 9th of July was correct or not.
My lord, it cannot be done now.
Kindly,
Kindly, my lord, kindly, if your lordship goes to the orders, kindly.
Let me finish.
If your lordship goes to the orders, my lord, it is clear that, my lord, if your lordship comes to the 6th August order of the honorable, my lord, single judge, which says, my lord, kindly sees 6th August order, this second order wherein their vacating application was dismissed, my lord, kindly come to the 3rd page. My lord, 3rd page, the dispute now is
Tell
with
me
regard
one
to
thing,
the
now
return of the bank guarantee.
affidavits have already been filed.
Yes.
What is your defense with regard to the allegation that you have relied upon fake and
My lord,
false
that is
documents?
absolutely a process of afterthought. My lord, 3 invocation notice, the first 2.
First one, we'll consider the first one first.
Yes.
Right. Where is the error on the part? The document, the terms and condition mentions that in case it is found that you relied upon
By
false
that
documents.
time, the bank guarantee lapsed, the tender was issued.
My lord,
It
on
was
9th
not
of
within
July,
the
it was
MD.
invoked, my lord, that time, my lord.
1 minute.
There was no document till that time. My lord, the 3rd invocation.
When was the tender notice floated?
Yes. My lord, prior to that, may I, my lord, request your lordship to come to page 3 of the 9th August order once. My lord, the dispute now is with regard to the 6th August order once. My lord, the dispute now is with regard to the return of the bank guarantee, which will be decided upon exchange of affidavits. Thereafter, your lordship comes to the last paragraph again. Now the court has to decide whether the bank guarantee used as a security should be returned after its expiry or not. Whether the ground that the authority had found an alleged false document in a bid document and had the authority to forfeit the EMD will also be decided. The presence of the government place. Now your lordship kindly comes to the division benches order, which confirms the single benches order.
No, I have seen that.
There, my lord, whether the allegation against me, whether I have submitted a false document or not, that has to be decided upon trial, upon examination of the documents. That is outside
Very
the
well, you go before the competent forum and get it decided. The court is not passing any order.
Very well, my lord, till
my
the bank guarantee should be returned.
My lord, kindly comes to.
Why will it be returned now?
My lord, because it has lapsed, it has lost its force already.
Very well, then let it remain with them.
My lord, then I will be, my lord, losing my retention money. My lord, kindly appreciate.
Try to understand that without the trial, the court cannot say whether the documents are false. Till such time, they will hold the guarantee.
My lord.
Yeah, but that cannot be re-invoked, your lordship. That is
may not be. Well, the court will decide.
May I, if your lordship, my lord, keeps it any other day, Mr. Shakoshen is leading me any day subject to your lordship's convenience.
Now, when you are in trouble, you.
No, I am not in trouble, my lord. Then, my lord, I have to.
From the very beginning, you did not say.
No, your lordship, my lord. If your lordship allows me, my lord, I will show all the documents one by one.
Allowing you.
Very well.
I'm certainly allowing you.
Very well, my lord. Kindly seize, my lord, the malafide on their part. My lord, I will request your lordship to come to page 94 of the writ petition.
My lord, first, my lord, they, my lord, answered to my lord, my preliminary objection whether this court has jurisdiction or not.
My lord, that issue cannot be decided now. After, my lord, the division bench holds up.
Kindly sees page 25 of my opposition, where, my lord,
my lord, the writ petition was in, my lord, within the jurisdiction for the only reason that the bank is within the jurisdiction to whom they have written a letter for invocation of the bank guarantee, which attracts the jurisdiction of this honorable court.
Page 94, what is there?
My lord, page 94 is the first letter of invocation, 26th March 2024.
Yes.
Yes. My lord, here, my lord, kindly sees the bank has undertaken to pay an amount to ECL on demand. This claim may be treated to be in line with the
Invocation terms
and
conditions of the bank
conditions
guarantee.
of the BG. Hence, the aforementioned BG may be invoked and proceed may be credited to SECL's bank account as per the details. So this is the first invocation letter without any reasons, as my lord stated. Now your lordship comes to page 101. The second invocation notice dated 15th of June 2024. The impugned notice with challenging which we came before this honorable court. At page 101.
Yes.
Yes. My lord, the same repetition of the same notice without any reasons. Now your lordship comes to the bank guarantee, because it is a conditional bank guarantee at the end of the day. Kindly sees, my lord. My lord, kindly comes to page 73 once of the writ petition.
Yes.
Yes. My lord, 35, column 35, serial 35. If the bidder withdraws or amends, impairs or derogates from the bid in any respect within the period of validity of this bid. So, my lord, that is over. That is when it was over. The moment, my lord, the bid was given to the successful bidder. And my lord, that was on 23rd of February 2024. That document I am showing to your lordship. Secondly, your lordship sees the other conditions. If the bidder fails to furnish the performance security for the due performance of the contract, fails or refuses to execute the contract. So these are the two conditions upon which the bank guarantee can only be encashed. Now your lordship kindly sees, my lord, when, my lord, the tender was issued to the successful bidder at page 80. Your lordship comes at page 80.
Yes.
My lord, 23rd of February 2024, this is the work order contract in favor of, kindly sees, my lord, Sujoti. Yes, Sujoti India Private Limited. So Sujoti India Private Limited becomes the successful bidder. I am out of the bid. Now, my lord, kindly sees, my lord, the James manual, wherein, my lord, the tender was floated, the actual committee. My lord, that your lordship, I have shown to your lordship once, my lord, that at page 93. 93, your lordship has seen what the James tender says, that once the bid was, yes, my lord, earnest money of unsuccessful bidders. So the moment on 23rd February 2024, I became an unsuccessful bidder. The earnest money of unsuccessful bidders shall be returned within 15 days after the award of contract or expiry of bid validity, whichever is earlier. However, in case of two packets of two
No, do not go to however, come to a bit top. N2. Same page.
Yes. Bid securities of unsuccessful bidders during first stage, technical evaluation should be returned within 15 days of declaration of result of the first stage itself. Technical evaluation, earnest money of
N2 at the top of the same page.
M2. If it comes to notice that the information documents furnished in its bid is false, misleading or forged.
The bid, so it can be forfeited.
Yes, when, my lord, within the bid period, validity of the bid period.
Where does it say so?
At Q it says so. Kindly P. Earnest money of unsuccessful bidders shall be returned within 15 days of the award of the contract or expiry of the bid validity.
Yes.
Whichever is earlier. So, my lord, the moment it was awarded to the successful bidder on 23rd February 2024, the period of 15 days starts. By which time, my lord, they could, my lord, raise this issue, or that I have given forged document to them, alleged forged document to them, and they can forfeit the earnest money. That is one. So, my lord, that 15 days. So, my lord, from 23rd February 2024, it expired on 8th March 2024. 15 days counts to 8th March 2024. Thereafter, my lord, what they do, my lord, they did not return my earnest money deposit. By that time, they do not have any information about any allegations of, my lord, submission of forged documents. It is their admission. I will show from their document. But, my lord, what they did with a malafide intention, my lord, they, my lord, bound us, compelled us to extend the bank guarantee. That your lordship will see, my lord, the first letter of invocation I shown to your lordship at page 94. It is after, my lord, the period of 15 days. They issued the
All right,
first.
please wait. Page 93 is the place that you are relying upon.
No,
N2.
my lord, my case is at page 73.
73.
Your lordship is aware, my lord, so far as the bank guarantee is concerned, that's a, my lord, independent contract. And my lord, I will show what they have actually done.
All right, I'll hear him, but then I just want to know what is your case. It's page 73.
Page 73, my
All
lord.
right, let the petitioner finish. All right.
Yes, my lord.
Yes. So, my lord, thereafter, what they did, they compelled us to, my lord, again reissue or extend the bank guarantee. So, my lord, under pressure, compulsion, my lord, issued the bank guarantee once again, extension of bank guarantee, my lord, issued. By which way they, my lord, compelled us? They issued a first letter on 26th March 2024. By that time, the earlier bank guarantee was expired. And that 15 days period has also gone. My lord, the first invocation notice, without any reasons, the bank turned it down. Thereafter, my lord, the second invocation notice on 15th of June 2024, the impugned notice at page 101.
Yes, then.
There are also no reasons. My lord, by that time, we had given SCCL authorities two back-to-back letters on, my lord, 1st of April 2024 and 2nd April 2024 for, my lord, not invoking the bank guarantee and for returning of the same. Because I was entitled to the bank guarantee by that time, after the expiry of 15 days of the GEM period. At page 95, your lordship will find that.
Page 95.
95, my lord, kindly sees.
Yes.
Yes. My lord, the first notice, my lord, 1st
Kindly.
April 2024, at the bottom, your lordship will see.
Kindly stop.
Yes. Because by that time, the first notice of invocation dated 26 March 2024 was already given to the bank by the SCCL authorities. And, my lord, thereafter on 2nd of April, my lord, kindly sees.
So this is more or less your grievance.
No,
What else?
not the grievance. My lord, there are other things, my lord. Thereafter, my lord, what happened? So, my lord, I was compelled to extend the bank guarantee for another 3 months, which I, my lord, did so, because otherwise, my lord, under the threat of invocation, that was, my lord, your lordship will see at page 96.
Yes, what else?
Thereafter, my lord, a third reminder notice was given to them for releasing of the bank guarantee.
Yes, it's the same thing. Then what
Yes.
happened? What is your defense?
No, my lord, now, my lord, what happened thereafter? My lord, kindly now comes to the bank's reply at page 11, 24th of June 2024.
In the opposition?
Yes, in the opposition of the bank, given by the bank, ICICI Bank. Page 11.
Yes.
My lord, page 10 was the second invocation notice by them. And page 11 kindly sees the bank's reply. Kindly sees, my lord, please note that your invocation claim is not as per the terms of the bank guarantee with special reference to line numbers as per table. Accordingly, you are requested to resubmit the revised claim in line with terms and conditions.
আলাদা কোনো affidavit আছে?
Formed on 23rd of August 2024.
Yes, page 11.
Page 11, my lord, kindly sees.
Yes.
Please note that your invocation claim is not as per the terms of the bank guarantee with special reference to line numbers as per table. Accordingly, you are requested to resubmit the revised claim in line with terms and conditions on or before the expiry date of the said bank guarantee. In case payment is being sought under the said claim, please note that your invocation claim is not as per the terms of the bank guarantee with special reference. The same thing is repeated. Thereafter, my lord, a second notice was given by the bank on 27th June 2024 at page 13.
Yes.
Yes. There also, my lord, the same thing was reiterated by the bank that it was not as per the terms of the bank guarantee with the special reference. And I've showed your lordship, my lord, the two conditions and the terms of the bank guarantee, on which, my lord, only the bank guarantee can be invoked and by nothing else. Now your lordship comes to their third invocation notice, that is of 9th July 2024. That is at page 21 of the same affidavit in opposition. Here, my lord, for the first time, after a period of 4 months, my lord, they raised, as per the terms of BG, the bank was undertaken and guaranteed to pay the amount to ACCL on demand, as per the approval communicated by beneficiary to encash the bank guarantee, as bidder submitted forged documents in bid tender. Bidder has impaired or derogated from the bid, refer line to 35 and 36 in BG, which I showed to your lordship. Accordingly, ACCL instruct you to encash the bank guarantee and treat this as a firm demand from ACCL and credit the proceeds to ACCL's bank account as per the details mentioned below without any delay. It was on 9 July, and our first interim order we obtained, that was also on 9 July. So, my lord, thereafter, the bank has written, my lord, to them. My lord, bank's reply, your lordship will seize at page 38 of the affidavit in opposition filed by the SCCL authority.
Yes.
Yes. So they stated, my lord, due to the order of the Honorable High Court, my lord, kindly sees, this is for your information that by the order of the Honorable Court, in writ petition such and such, as passed on 9 July, the court has directed that any invocation request is required to be stayed, and hence we are unable to accede to any invocation request until we receive any court orders to the contrary. Now your lordship kindly sees, my lord, the interim order, which, my lord, the vacating application, which was dismissed by the Honorable Single Judge, my lord, was on this basis that, my lord, this demand and these reasons citing for the invocation of the bank guarantee was a process of an afterthought. Because, my lord, there were 3 notices after the expiry of the date of 15 days that, my lord, the SCCL authority did not return the bank guarantee, which they are supposed to return as per the James manual. And, my lord, they themselves, my lord, kindly comes to page 41 of this affidavit in opposition only, of the opposition filed by the SCCL authority. My lord, they are claiming that they claim to know, they have come to know of this alleged forgery from ECL authorities on, my lord, 14th of June 2024. So, my lord, 14th of June, and, my lord, kindly sees the first invocation was on 26th of March. And, my lord, kindly sees again, my lord, the date of expiry of 15 days on 8th of March 2024. So, by that time, there was no information to the SCCL authorities by their own admission that there was any allegation of fraud by me. So, they are supposed to return that bank guarantee by those two, that after the expiry of the 15 days period, which they did not return. To which, my lord, now my lord, I will beseech your lordship to come to that again, that dismissal of the vacating application order, my lord, on 6th of August 2024. My lord, may I read that order from page?
In the notice inviting tender, where is the clause for forfeiture of the bank guarantee?
Yes. My lord, notice inviting tender is at page 39. It starts at 39, my lord. I am showing you that relevant page. Yes, my lord.
Kindly come to page 67 of my opposition filed by the SCCL. That's the tender. That's the tender.
My lord is asking from the tender, where is the
This is part of
provision?
contract as well.
JMA. None other. Tender is a separate document altogether.
This is there. He shown me at page
I will be covered, my lord, under N2.
N2 is shown. How are you covered under N2?
Kindly read N1 and N2. I will make the distinction, my lord. So far as N1 is concerned,
No, my lord, my lord.
so far as N1 is concerned,
the question of JAM, JAM has, my lord, closed the issue.
Not JAM. The
No, he's relying on the JAM manual.
no, you show me from the
My
tender.
lord, I'm trying.
so far as N1 is concerned, that is within the validity period. N2, my lord, doesn't have any period. Kindly see the difference.
JAM has closed the issue.
N1 is
This
if he
issue,
withdraws within the validity period, then N1. So far as N2 is beyond the validity period.
My lord, after
N2 doesn't give any
after they
period.
failed before the honorable division bench, what SECL
My lord,
authorities have done.
kindly sees the order of the honorable.
Show me where in the bid document there is a provision for forfeiture or return, whatever. Show me.
My lord, at page 40, your lordship sees the EMD amount is 50 lakhs.
Page 40, EMD amount is 50 lakhs. Yes.
But return, I'm not being able to.
It has to be somewhere.
My lord, I'm trying. My lord, I just indicate one thing, my lord. After they failed before the honorable division bench, what they tried to do, they tried to raise the same issue before the JAM manual. There were several correspondences which were submitted by both the parties before the JAM authorities. JAM authorities, after proper adjudication of the matter, my lord, has closed down the issue. Which, my lord, I do not know. My lord, I have the document, my lord, but it is not printed with me. My lord, if your lordship kindly gives me a day's time, my lord, produce that order of the JAM management wherein they have closed the issue. My lord, kindly seize page 51 once. Yes. My lord, kindly come to page 51 once.
Yes. Lord, kindly come to page 48.
Before that, page 51.8. The release of the performance bank guarantees after above indicated period shall be subject to satisfactory performance of the equipment items. No, it is for the persons who are performing the bank guarantee.
This is the performance bank guarantee. What about the EMD?
EMD. It's not about the EMD.
Yes, sir.
Well, JAM manual says that EMD has to be returned to the unsuccessful bidder within 15 days.
All right, please wait. Yes, your submission.
Yes, ma'am. My lord, my first submission is that this writ application is not mentally event before this honorable court.
Now, see, after the division bench,
kindly see the division bench order then.
Yes.
Kindly see the division bench order.
Well.
Yes.
Kindly comes to page 25 of my opposition.
No, division bench order.
I am showing. I have annexed the doc order. I will not.
February 25.
7 February 25, yes. My lord, kindly seize.
My lord, kindly comes to page 25. 1, 2, 3, 4th line.
No, prior to that, kindly comes to internal page 2 of the order.
When I am
let him place.
Very good.
Allow me to submit.
Yes, sure.
The several issues need to be adjudicated more particularly when there is an allegation of fraud. Therefore, we are of the view that the learned single bench was justified in granting an interim order. One more issue which we need to point out is that the bank guarantee which was given by the respondent petition had elapsed on 12th of July 2024. Thus, we find no ground to interfere with the impugned order. But what was the impugned order? Impugned order was for, my lord, stay on the bank guarantee. And my lord, I went before the division bench to contend that this stay should be vacated. So, my lord, against the, my lord, impugned order, my lord, I did not succeed. Then accordingly, the appeal fails, dismissed, and the appellant is directed to file their affidavit in opposition within the 3 weeks from date, reply if any within a week thereafter, after which the appellant is granted liberty to mention before the learned single judge for taking up the matter at an early date. Such was the urgency. When I have also, before the division bench also, my lord, I have taken the point of my lord jurisdiction, that was, my lord, not decided. So, my lord, I was granted liberty to file an affidavit in opposition.
That was not even recorded. Where is the recording that the issue of jurisdiction was?
My lord, whether it has been recorded or not, my lord, when I have filed the affidavit in opposition, honorable division bench has not decided anything, my lord. That issue is, my lord, before you. It is, my lord, pending, my lord.
Show me where is the your reason for invocation of the bank guarantee. Show me.
My lord, kindly comes to page 37.
Yes.
9 July 2024.
Right.
Kindly see the I have invoked within the validity period.
This is the
Page
third
37.
invocation.
Please
Ma'am,
wait.
Sorry, ma'am.
It is not the when you invoke, the reason for invocation.
Well, reason for the invocation is there in page 37.
Right. Now, this is long after
Yes.
the contract is executed.
No.
The petition, what? No. Contract is executed.
Contract was my lord given to some other party.
Wait.
Some other party.
Successful
Now,
purchase
my
of
lord, kindly appreciate. We are a public sector undertaking.
Yes.
Now, my lord, we had information that there was something wrong with the
Right.
bid submitted by the petitioner.
If you
Now,
get late information.
Until and unless
Hmm.
we get something in documentary form,
Yes.
we cannot on air, we cannot bring the allegation. My lord, as your lordship is well aware that Coal India has 12 subsidiaries.
Yes.
We are the one of the subsidiaries of the Coal India. And my lord, so far as this petition is concerned, my lord, they were required to, my lord, supply some life supporting equipments for the purpose of evacuation in the coal mines. So my lord, so far as this petition is concerned, he has not only participated in the tender which was floated by SCCL, but he has also participated in other tenders which have been floated by the other subsidiaries. But when my lord,
Relying on the same documents.
Self document. Now kindly comes to
1 minute. 1 minute. And where the petitioner has relied upon false documents, contracts are still there?
No, my lord, not there.
They are over?
My lord, no, so far whether those contractor over or not, I am not aware. Not kindly comes to the communication that was given to us by the ECL prior to my lord this invocation, which is at page 37. Kindly comes to that, what they have done.
Whether you could have waited till such a time or not is the query of the court.
Yes, my lord. Yes, my lord. Kindly comes to then end to once.
When was the bid floated? Date of floating the tender?
9th of October 2023.
9th October 23, within which the bid were to be submitted. Does your list of dates say all
My lord,
these
we
things?
submitted our bid on 9th November 2023.
Ninth November 23.
Yes.
And contract executed?
My lord,
23rd
of February 2024. And my lord,
after that.
Yes, lord. I am coming to that. Kindly comes to page 67.
Yes.
And
it's the full court document.
Of my opposition.
Their opposition. 67.
It is pages.
67, lord.
It is page. It is there in the writ also, 93. Page 93,
Yes.
same thing.
Peace security submitted by the bidder shall be forfeited if the bidder, clause 1, withdraws or modifies or impairs or derogates from the bid in any respect within the period of validity of its period. So far as clause 1 is concerned, for that, my lord, if I have to bring the charge, that shall be within the bid validity period. Now, my lord, kindly comes to 2. If it comes to the notice that information, if it comes to the notice that the information documents furnished in its bid is false, misleading, or forged.
Yes.
So far as second part is concerned, my lord, it does not say that it shall be within the bid validity
To be
period.
within the validity.
Kindly let me finish.
Wait, please wait. Yes.
Now, my lord, so far as the information with regard to, my lord, submission of forged document, that has, my lord, come to us on writing on
14th of June 2024 at page 41 of their opposition.
page 43. My lord, kindly comes to page 43.
Yes.
My lord, this request process, we cannot, my lord, say it one go that was, my lord, forged.
Yes.
My lord, kindly seize the letter, the communication which was made to us. This has reference to our JM bid number so and so.
Please come.
My lord, our affidavit is already
On record.
Your
You
lordship,
do not have a say.
Your lordship, I'm led by Mr. Singh.
Because, my
The
lord,
petitioner.
the thing was whenever it was not in proper format, we have already disclosed. That's why rejected.
All right. The petitioner.
Kindly, my lord, they could not give because of the interim order.
The petitioner has prayed for a declaration that the
Your
notice.
lordship, I'm led by Mr. Sen. He has come.
Yes. Dated 15th June 2024, issued by the respondent, Southeastern Coalfields Limited. By which the bank guarantee was sought to be invoked, was not binding upon the parties in any manner whatsoever. Stop. The parties have exchanged their affidavits and have made submissions. Stop. It appears that a tender was floated by উপরে যেটা সাউথ ইস্টার্ন বললাম ওখানে ব্র্যাকেটে SECL লিখে দেবেন was floated by SECL on 9th October 2023. Stop. The petitioner participated in the tender process and submitted its bid on 9th November 23. Stop. The bid of the petitioner was not accepted and the contract was executed by SECL with a third party on 23rd February 2024. Stop. For participation in the tender, the applicant was required to submit an earnest money deposit by way of bank guarantee for a sum of rupees 50 lakh. Stop. As the petitioner was unsuccessful in the bidding process, the petitioner seeks refund of the bank guarantee. Stop. SECL has refused to return the bank guarantee, which has in the meantime expired, on the ground that the petitioner furnished in its bid false, misleading and forged document. Stop. Paragraph. The not the SECL got the information
only one thing
regarding the false document submitted by the petitioner in June 2024. Stop.
Only one thing, my lord.
Paragraph.
Page 39, 120 days was the bid offer validity. At page 39, your lordship had a query on this. Bid offer validity, it was for only 120 days.
As per the bid document, the bid offer validity period from the end date was 120 days. Stop. The bid end date was 30th October 2023. And the bid opening date was also 30th October 2023. Stop. The first invocation was made by SECL.
My lord, on 26th March 2024 at page 94.
On 26th of March 2024. Stop. The bank guarantee had expired by then. Stop. The petitioner had to renew the same, allegedly on the pressure created by SECL. Stop. Paragraph. It appears that the bank guarantee contained certain conditions. Stop. The if the bidder, no, if
My lord, at page
as per the ওটা কেটে দিন, the
73.
general terms and conditions of the GEM portal clearly mentions that the bid security submitted by the bidder shall be forfeited if the bidder withdraws or modifies or impairs or derogates from the bid in any respect within the validity period of the bid, or if it comes to notice that the information / documents furnished in its bid is false, misleading or forged. Stop. According to SECL, as SECL received information regarding submission of false, misleading and forged document by the petitioner, accordingly, the bank guarantee has been directed to be renewed, as the SECL intends to forfeit the same.
My lord, on the third invocation.
Paragraph. Whether the specific submission of SECL is that the clause for the clause permitting forfeiture on account of submission of false, misleading and forged document does not specify the time period within which the bank guarantee can be invoked. Stop. Though if there is a when there is a modification or derogation from the bid, the bank guarantee may be forfeited within the validity period of the bid. The SECL interprets the clause in such a manner that whenever it comes to the knowledge of the authority that the bid is false, misleading
for encashment
or forgery, the কি বললাম শুরু করলাম yes ঠিক আছে, the authority can proceed to forfeit the bank guarantee.
Only one thing, my lord, the third.
Will you please stop?
My lord, they have taken
Will you
condition
please
one
stop?
that I have impaired from the bank guarantee. That was the only condition.
Please stop.
My lord, if your lordship comes to the third invocation notice once.
Rest I will dictate in the chamber.
My lord, kindly seize, my lord. My lord, I'm sorry, my lord. My lord, kindly seize the page 37 once. It says that bidder has impaired or derogated from the bid. That was the reason given by them, my lord. Kindly seize, my lord. So they have not taken this point of, my lord, submission of false document. My lord, I'm sorry, your lordship, my lord, I thought I should, my lord, indicate to your lordship on this.
My lord, on the issue of
Your lordship, do not take me amiss, my lord. It is my duty, my lord, to, my lord, assist your lordship only for that reason, my lord.
Yes, call the appellate side matters.
My lord, item number 1, my lord, I am for the respondent.
Yes.
I do not know why it has come for release.
Somebody has mentioned it.
My lord, I don't know what is the reason of release.
Was notice of mentioning given?
No.
To you? No notice given.
Follow the
Direction was that notice should be given. I do not know why notice has not been given.
Just gives me a minute. Why was notice not given?
It was specifically mentioned, and this court ensures that without notice matters are not heard. Nobody should be just taken amiss that the court has permitted inclusion in the list without intimating the other side. This is not done.
I absolutely apologize.
And then are you ready?
My lord, I'll tell you, lordship.
Release.
Let him say for what? I do not know for what.
I'll indicate to my lord.
As it is, we don't get to appear much before your lordship. That also we have come up with an innocuous prayer.
No, but you maybe you do not appear, but your junior appears in so many matters, and I can remember that he was there and the court directed him to serve notice.
That is different, my lord.
So
So far as we are
all
concerned, my lord,
right.
we normally appear in the criminal side, so we don't get your
Correct.
lordship. This is a matter where possibly we thought that we'll be able to do the matter before your lordship. But unfortunately, my lord, there's a situation which has happened, for which, my lord, I'll apprise your lordship of the situation first.
No, you cannot do the matter here. You want it to be released. This bench doesn't have determination
No,
on
it
what.
has the determination.
But then you want it to be
What has
released.
happened is, my lord, the predicate offense which was there, this is a PMLA proceeding which has been challenged before your lordship.
All right.
My lord, the predicate offense which was there, my lord, it was quashed. Now, how it was quashed is because, my lord, the FIR which was initiated led to a closure report. And then the learned magistrate directed that since the de facto complainant did not, in the predicate offense, the de facto complainant did not wish to continue further, the learned lower court, trial court, closed the proceedings. While the matter was pending in the lower court, we had moved, one of the parties had moved for quashing of the proceedings before the high court. Now, the lower court proceedings got closed. We were one of the parties who was an accused in that, was not aware. A report came from the lower court to the high court. The parties before your lordship, we had filed for quashing of the proceedings. A report came from the lower court, which was forwarded by the public prosecutor, indicating that the lower court proceedings have stood terminated. So there was no question of proceeding further with the quashing. My petition was effectively declared infructuous, and the petition was dropped. My lord, your lordship knows that there is some dichotomy over the legal issue. But however, the Honorable Supreme Court is of the opinion currently that predicate offense must be existing, based on which PMLA proceeding must go on. The PMLA proceeding, my lord, was challenged before your lordship by way of this writ petition. Now, in the meantime, what happened was, my lord, ED, who's not a part of the quashing proceedings, my lord, since predicate offense involves only the accused and the complainant, ED intervened and filed a revisional application before the High Court, saying that the lower court quashing was improper and the High Court should intervene in a matter which is of a particular magnitude. The High Court stayed the order of the learned magistrate, though the closure report is on board. So now what has happened is the High Court, on the strength of ED's application, quashing petition, is going to rehear the predicate issue. Predicate offense issue.
So you want this matter to be tagged there?
My lord, we filed an application before that particular court.
All right.
Indicating, my lord, this is the application that for fitness of things,
So why don't you file a similar application in this matter also?
If your lordship is desirous of an application,
because let all these things be brought on record, so that order can be passed and the matter can be released from this bench, so that it can go before the bench taking up the other matter.
In all fairness, my lord, I thought that the ED is going to support us because this issue.
I do not know.
But I think if he's not supporting us, then I'll have to file an application and bring it to your lordship.
Because the application filing will be a wiser way, because you never know where the matter is going to end up. As to why this bench is releasing, everything has to be written in that case. So it's better you come up with an application, a composite application, disclosing all facts, serve a copy. Necessary order can be passed.
Very well. Honestly, as
everything remains clean.
Yes, Manoj. We don't have. I honestly thought that the ED will be supporting because it was their cause.
He doesn't know possibly.
Well, I can say no. I am doing both these matters.
Also, are you aware?
I am aware of all these facts. What my learned
Then, in that case, can it be sent over there?
Submission. As on date, this writ petition prayer was ED proceeding cannot go on because the predicate offense FIR has been closed.
Yes.
As on date,
that is
after the order of the Honorable Revisional Court's order, stay on that order. This writ petition, possibly they cannot even move this writ petition before your lordship.
Very well. In that case, I'll send it over there. Since you are aware of all these facts, can I send it?
I'm aware of all these facts.
Then I'll send it.
But your lordship will kindly record that I have made that submission, that there is no requirement of release of this matter.
Just imagine.
That is my submission. Because this is a writ petition which depends on the order quashing the FIR. So this is not necessarily to be taken up by the same bench in a criminal revisional jurisdiction. So because today they cannot move this writ petition, they want to get it alive by way of a transfer. Where I was, because if
by way of a transfer.
Yes, by way of a
one bench to the other is not
if
transfer.
your lordship takes up this matter today.
Yes.
On merit.
All right.
My submission would be that writ petition does not stand on merit.
Yes,
That is my submission to
because that order is stayed.
that order is stayed, which they are both the orders, two orders. My lord, 156(3) application
Hmm.
disclosing offense of
decides to act on merit.
of corruption has
It's
been
better you come up with
yes.
an application. Disclose all facts.
offense has been withdrawn.
Because the ED is not
Outright
supporting you.
settlement.
Well, very well, because initially I thought that he will. The way he submitted right now also he will.
Acha. The
Very well.
the
I'll file an appropriate application.
the petitioner prays for releasing the matter from the list of this bench so that the same can be placed before the bench taking up criminal revision matter where
The predicate offense.
the predicate offense is being decided by the court.
My lord, CRR 2781.
তো ওটা আছে তো, application এ copy
Yes,
দিলাম।
yes.
2781 and 2782. Both.
In CRR number 2781 of 25, 2782 of 2025. Partyর নামটা লিখে দেবেন।
That application I am not aware of.
Huh?
Grant two.
Directorate of Enforcement, Kolkata Zone 1
বলছি আমি তাই।
versus the officer in charge, Electronic
বলছি
Complex
আমি তাই।
Police Station, Bidhannagar Police Commissionerate. ঠিক আছে? Top. Learned advocate representing the respondents oppose the submission of the petitioner. Stuff next. The petitioner is granted liberty to file an appropriate application disclosing the facts and the reasons seeking release from this bench. Let a copy of the said application be prepared and handed over to the learned advocate representing the respondents.
But
Liberty
may-
to mention upon notice.
May I just request for one indulgence? Your lordship, release and to be tagged just indicates that.
Actually, released and
And to be
tagged
tagged.
along with
Otherwise,
that
it would
matter.
have seemed that is
Yes,
grateful, man.
It can be tagged there.
We will see to that.
No, by this order.
No, it's not by this order. At least released and then
I don't know whether you.
no, he'll come up with an
I'll
application.
come up with an application. It is best to keep things on record, my lord. I understand. Grateful, my lord.
My lord, where your lordship has recorded my opposition, will it be your
Yes,
pleasure?
I have recorded your opposition that you are opposing the prayer for release.
I have opposed your lordship.
Yes, I have recorded.
Will it be your lordship's pleasure to add one more sentence that I have said, because to my understanding this writ petition today is of no merit.
Let him come
Because
with the application, then I'll record everything.
Otherwise my opposition, why I have opposed even very.
My lord,
It doesn't matter.
Anyway, whatever,
Grateful,
your
my lord.
lordship.
Let the application come.
I'm appealing the state respondent.
My lord, I am appearing for the petitioner, my lord. Lastly, lordship has extended the matter.
31st of July, the interim order expired.
Yes, my lord.
But
because
the
of
matter was running in the list.
Yes, my lord. My lord, because of
Yes.
But so far as the
Party
extension of interim order is concerned, my lord, I have nothing to say, but the issue is very short matter, my lord. Let it be taken up any day, my lord, so that, but the only issue is that whether they have a 5 years experience or not at the time of joining the tender, my lord. That is the only
Joining
issue.
the tender.
In the NIT, there has been a categorical mentioning that they should have
affidavits already
5 years,
exchanged, my lord.
if it
It
is
is
extended.
appearing in the list under the heading hearing, my lord.
Yes, yes. Yes.
They should have a 5 years manufacturing and marketing experience.
All right.
But on the date of filing their tender, my lord, it appears that they are having in 2 licenses, which are not at all. None of the licenses are of 5 years. So they cannot have these 5 years of experience. This is the only point to be decided. And therefore, it has been stated that they have
You
suppressed-
terminated the contract midterm.
Yes, the reason is they have said that we are holding this 5 years experience. Now, thereafter, it has been detected from the record.
Thereafter, did you permit the petitioner to complete the work?
No.
My lord, he was continuously.
They have
doing
been
the work.
blacklisted as per the NIT itself because they cannot make a false declaration. Well, that is the only point to be decided because they are holding 2 licenses. Both the
No,
licenses are.
I have followed. Tell me one thing. After termination was stayed by the court.
Yes.
Did you continue with the work? No.
That work we are not.
You've not continued.
I have to take instructions so for that point also, but other works we are doing, my lord.
So other works are not
My
terminated.
lord, I have to take instruction regarding this, my lord, because after that, the debarring from the work-
Stay of operation of the order of debarment.
Yes, my lord.
In future tenders, this is under stay.
Stay.
But the work, the petitioner could not conclude the work.
Well, that I'll have to take after
Termination.
that instruction is not available. my lord.
I
Please
have
come.
to take also, my lord.
The matter is ready for hearing and was running in the hearing list for quite some time. Stop. In the meantime, the interim order expired on and from 1st August 2025. Stop. The matter has been mentioned, praying for extension of interim order. Stop. Paragraph. In the facts and circumstances of the case, the interim order that was subsisting till 31st July 2025 is reimposed, and the same stands extended till 19th December 2025 or until further order, whichever is earlier. List the matter in the hearing list on 22nd August 2025.
I'm grateful.
Keep replies, my lord.
22nd August. 19th December, what did this say?
Lordship, I appear for the petitioner.
Yes.
Before I address my lords, a very embarrassing situation. I mentioned by me there is urgency, my lords. I am led by Mr. Shuddhasatwa Banerjee. He has hurt himself. He couldn't come to court today. If your lordship could kindly allow.
Last occasion, possibly this was also.
No, lordship. This is for the first time. I
For the
mentioned
first
it
time?
last week. Lordship
Alright.
was allowed it today, but
Yes.
I'm ready, my lord. But because I have a leader, lordship, would I kindly accommodate me for one day? I can come back tomorrow on the same. If it remains on the same level, my.
And the hurt that the learned counsel has,
I
will
had
he be able to recover?
word with him in the morning, my lords. He said that he'll be coming from tomorrow. He couldn't make it today. That's what he said, my lords. I am otherwise ready. If there's urgency, I understand. Only thing, because I have a leader, my lords, if this could stand over till tomorrow, retaining the same
Very well, not today only.
retain the same position. I'm so grateful, my lords. I'll come back.
My lord, earlier matter, my lord, 22nd, my lord, I will be out of session for my medical examination, my lord. My lord, kindly fix some other date, my lord.
29th of August.
Keep reply.
29th August.
Good, my lord, I am for the petitioner, my lord.
I appeal for the respondent bank, your lordship.
This is a matter, my lord, where the petitioner is a septuagenarian lady, my lord, who cannot draw her pension because of the fact that she is suffering from dementia, my lord, and he is under the care and control of his only nephew, my lord, who is taking care of the. So my innocuous prayer in this writ petition is let
There is
the,
nobody else apart from the nephew.
apart from the nephew, there is nobody else. It is recorded in the PPO also, as well as in the pension, as well as in the nomination form. Page 27, your lordship will find. Page 27, my lord.
Yes. Did you approach the bank?
Yes, I have approached the bank, my lord. Only if the bank could allow her to withdraw the pension by the left hand thumb impression.
My lord, after this representation, my lord, the bank have duly sent a reply. I did not get a proper copy of that reply. I'm not being able to place it before
We
the
have
court.
also not received it.
In the reply, my lord, it has been stated to kindly substantiate the claim of this present nephew with some documents so that, my lord, they can also allow them, because the prayer of the writ petition, the prayer of the nephew before the bank was to allow him to operate the account, or, my lord,
Do you all conduct any medical checkup or anything of that sort? Only relying upon the medical certificate.
Yes, madam.
You all permit this.
Yes, madam.
So what the nephew is required to produce
My
before
lord, the
you?
nephew have not given any document, the pension PP order and everything which they have annexed, my lord, that was not placed before the bank. So the bank does not know that whether the nephew is actually.
Now, upon getting a copy of the writ petition,
My
all
lord, the writ
documents are
petition
there?
copy has not been served upon the bank. In view of the urgency, it has been served upon me, your lordship. Very innocuous prayer for your lordship. Kindly regularize my appointment. And my lord.
Regularization I cannot do
Lordship,
because
lordship.
it is between you and your
Lordship,
client.
I have spoken.
I
with
can
the bank,
adjourn it till next Monday. In the meantime, you take instruction or
my lord, I'll bring, and my lord, regarding that.
by Monday, will you be able to get
Yes, my lord, the reply is there with me, but it is not a good
All right,
copy.
please come.
No, who was prayer, my lord?
The petitioner is a septuagenarian lady who is currently suffering from dementia. Stop. Prayer has been made to permit her nephew to operate the bank account on her behalf. Stop. Learned advocate representing the bank seeks time to take instruction. Released on 18th.
Lordship. Grateful, Judge. Affidavit of service.
A written instruction clearly mentioning the formalities required to be complied with by the petitioner
Lordship.
to allow the prayer as sought for shall be clearly disclosed in the instruction to be forwarded by the bank.
Lordship. Grateful, Judge.
Service is taken on record.
But I am for the petitioner.
Yes.
But there are a bunch of analogous matter. Some matter has been assigned before code number 551 and one matter has been assigned before your lordship. But in respect of other matter, tea time matter was hard and it has been fixed for order on 22/8. 22/8.
Not for order. Matter hearing has not been
3
concluded.
days. But
Seven matters
that
are
coordinate bench has.
You don't want the matter to be taken up by this bench.
No. I want Malad.
No.
Only I am praying Malad. After 22nd August, lordship kindly fix this matter.
All right. On the prayer made by the learned advocate representing the petitioner, release the matter on 1st of September.
Get one Malad.
The division bench settled everything. No. I was thinking.
I'm appearing with Mr. Amal Mukherjee, my senior.
Yes, will clear everything.
Honorable division, before the honorable division bench, they paid for withdrawing the false cases, your lordship. Every time they are doing the same. So since the bench has, determination has changed, it will be listed again on 14th of this month, your lordship.
So I'll adjourn it after.
Yes.
It appears that the Honorable Division Bench, in ceasing of the matter, is has fixed the matter for consideration on 14th August. Stop. In view of such submission, hearing of this matter stands adjourned till 2nd September.
Deeply obliged, your lordship.
Gratefully, your lordship.
My lord, payment dues to Devang Sudhindra not present here.
He was present some time back. Call him.
Already called, but he not ringing. Already called, but he not catch the phone.
Maybe he's engaged.
Okay.
I'll place it on Friday.
Yes.
None appears on behalf of the respondents. Stop. List on
Friday holiday.
22nd.
22nd.
I beg to appear for the petitioner, my lord. Today, the petitioner has been called at the BDO office for a hearing, my lord. I humbly beseech your lordship to kindly take up this matter next week. So within that period, the reasoned order may come.
This is regarding payment of dues.
Yes. Payment of Friday.
Learned advocate for the
The
petition
last petition
submits
Friday,
that,
since the state had taken time, your lordship had fixed it.
submits that the petitioner has been directed to appear for hearing in the office of the block development officer today. Stop. Prayer has been made to adjourn hearing of the matter for the time being. Stop. In view of such submission, released on 22nd.
My lord.
Under the heading payment of dues.
I'm deeply obliged. Okay.
But I am appearing on the state respondent.
I appear for the petition, my lord. Vicky.
That is, I filed the in opposition.
Yes.
My reply.
The
Yes.
tender process was initiated by the Fisheries Department for Malad fish feed in 2000, in December 2018. There are 4 tenders. The petitioners got, the petitioners tenders were accepted. 4 work orders were issued, in between January and February 2019. Now, against such, the system was that as soon as the demand is made, I was required to supply. So we supplied in respect of 3 work orders. For the 4th work order, no demand was raised. Now, those were consumed. It was they consumed it, they used it. There was total, I raised invoices of around 3 crores 75 lakhs 18,000 and odd. Out of that, only 2 crores 8 lakh 40,000 the payment was made. Balance of 1 crore and 66 lakh 78,000 was not paid. We applied in 2022 under the Right to Information Act. The reply suggests that there was a committee constituted by them and committee recommended for payment.
Lordship, in this matter, Lordship, Lordship, in this matter, oh, I see.
Committee recommended the payment.
What you want, adjournment?
Lordship, the senior was changed, Lordship. I am paying for 2 weeks' time for allotment of.
You should have asked it, Madam.
And the opposition, and just today I got the reply, Lordship. I give them 3 or 2 months before, but I got today.
Affidavit in opposition by the respondents and the reply thereto by the petitioner filed in court are taken on record. Stop. Learned advocate for the state respondents seeks adjournment. Stop. In view of such submission, released on 22nd August 2025.
Okay.
22nd of August.
Grateful, Madam.
Highly appreciate.
Under the heading for hearing.
Yes.
Yes.
Let it remain in the same position, Madam.
No, adjourn motion.
Yes,
Here.
better.
I'll take it up in the hearing. Supplementary list.
As you have said.
Item number 10.
Lord, I am opposing this application.
My lord, I am for the petitioner, madam.
Yes.
My lord, on the last occasion, my lord, please to direct me to file an exception to the report filed by the state.
Yes.
But this is a small issue, my lord. I have been blacklisted without giving an opportunity of being heard. My lord, they have served us notice. And to that effect, my lord was pleased to direct them to submit a report into the form of affidavit, my lord. In the affidavit, my lord, they have attached the postal receipts, and it is written that I was not present in the house, my lord.
In the?
I was not present in the house.
House. All right.
It is noted as there, my lord. And my lord, I have filed an exception, my lord. I have annexed a medical document. If I presume that it has been served, my lord. My wife was ill. I stay in Bonga. This is stay in Bonga.
All right. And
Almost-
where is the address? Recorded address?
Bonga. Both are Bonga. For her treatment purpose, I came to Kolkata several times. But even I am not going on that topic, my lord. My lord, kindly takes the report filed by the state, my lord. Who has affirmed this, my lord?
Yes.
My lord, he's the SDO Bonga.
Page.
My lord, the report.
Report. SDO Bonga is affirming it.
My lord, kindly comes to the writ petition I have filed.
Yes.
Page 21 of my application, my lord. It is one of the letters sent by them on 23rd of September 2022. I was not present. I came to know that some letter came to my residence. I have written the letter received by the SDO Bonga. They have not intimated anything. I have informed that a letter came. I came to know. I went to post office. They said we are not in a position to hand over it because we have sent it back. So I again went to SDO Bonga's office. I also intimated them. I have not received. They have sent it has returned, but I have not received, my lord. In that anticipation, I have already written and they have received that. SDO himself received it, my lord.
Where is the termination order or something? Blacklisting.
I came to know about the termination in respect of another tender, my lord. That
Lord, at page 41, my lord, on my report, R16.
23 in my writ petition.
R16.
I came to know.
This is dated 23.
In my petition, page 23, I came to know in respect to another tender that I have been blacklisted here.
Yes, the date of blacklisting is 23.
23, 9th January 20.
Oh, this writ petition is also of 23. All right. And which page in the opposition were you referring to?
Lord, may I place my opposition, Lord? Ample opportunities were given to him, Lord. And Lord, if your Lordship kindly takes, Lord, page
For what is the period of blacklisting?
3 years.
Lord, 3 years. Previously,
From 22 to 25, possibly the 3 years will expire.
No, not
no,
expired.
not yet expired.
25, it will expire.
It
This
has
year.
26.
9/1
From 9th
9
January
January 2023 to 3 years.
In the January 2023.
Yeah.
For
Previously, he was blacklisted.
Previously also
Yes, in the
blacklisted.
year 2000. No, not at all a separate issue. 2015. He was blacklisted. That I have annexed. But if your Lordship kindly, my Lord, I will demonstrate everything in my. I have demonstrated everything in my report. But if your Lordship kindly takes trouble to take page 4, Roman 6 of my reply. Has your Lordship got it? Page 4,
Yes.
Roman 6. May I place? It is stated that the tender committee then decided to seek. Previously, a NIT second call was floated. Milord, he was the one of the bidder. He has quoted some rate which is 25% below the marketing rate. That's how we have sought for some explanation. There, paragraph 6, Roman 6 starts. It is stated that the tender committee then decided to seek clarification from the petitioner hearing on his quoting such lower rates for the 11 number item and the letter issued by bidder memo number such and such, dated 31st January 2022. Asking the petitioner to put up his plan to supply the items according to the rates quoted, which is below 25% prevailing market rate, maintaining quality. Without said letter is annexed. Without page, your Lordship kindly comes to page 5, paragraph Roman 8. It is also stated that the clarification of the petitioner herein was duly accepted, and a letter of acceptance of various rates of articles quoted in the said tender was issued to the manager such and such, and the petitioner was further requested to said letter to deposit the security money of 30,000 and to execute a deed of bond of agreement with the government on non-judicial stamp paper. And paragraph Roman 9 says, as per clause 12 of the NIT, he is mandated to execute deed of agreement within 15 days and also deposit the security money. Thereafter, your Lordship kindly takes page 9, paragraph 9 of page 6. Thereafter, second reminder letter was given on 11th April 2022, was issued to the bidder for execution of deed of agreement by depositing security money by such and such person. It is further stated that having received no response from the petitioner herein, further reminder was issued to him for depositing the security money, such and such dated 23rd May 2022, but the bidder refused to receive the same as informed by the Indian Postal Office. We have annexed all the postal receipts, the refusal. 9, the Roman 11, it is stated due to continuous failure on the part of the petitioner deposit the security money to make an agreement thereto, a resolution of the tender committee dated 19 September 22 has been taken as to show cause him. Kindly takes page 7, Roman 12. It is also stated that the first show cause letter was issued to the petitioner with a memo number such as dated 21st September 2022 by the manager. Show cause notice is annexed. It is stated that the postal office could not deliver the letter due to continuous absence of the petitioner. Thereafter, petitioner was issued another show cause notice, dated 17th December 2022. Again, postal office could not serve the letter of show cause to the petitioner even after 3 different attempts. Postal receipt is also annexed. It is most especially submitted that the letter of acceptance was issued to the petitioner vide 24th March 2022, which I have demonstrated before your Lordship. And even after 2 reminders, that is 11th 4 2022 and 23rd May 2022, and further show cause notice issued dated 21st September 2022 and 17th December 2022, neither the petitioner turned up for nor communicated in any manner with the authority. It is also said that despite being given ample opportunities of hearing, when the petitioner failed to respond and didn't receive any show cause letter, the tender committee was compelled to blacklist him by resolution dated 9 January 2023 with a memo number such and such. So, my lord, ample opportunities were given to him. My lord, page 9, your lordship kindly takes, my lord, paragraph 19, Roman 19. It is most responsible that the petition was earlier blacklisted for 3 years in the year 2015 video order number such and such dated 8 July 2015 issued by the same authority. So, my lord,
Not the same.
my lord, if you, my lord, I have annexed all the postal receipts, my lord, ample opportunity.
All right. Yes.
Kindly comes to page, what my senior friend has referred, my lord, his report kindly comes to page 7. Roman 12.
Yes.
Roman 12, my lord. Letter dated 21st September 2022. My lord,
This is only one letter. There are so many letters.
That I was not present, my lord. In every, there is endorsement postal receipt that I was absent. Nobody was at home.
Yes.
Even one letter his wife received.
No, thereafter, prior to that, the last one, apart from the last one, prior to that also, there are so many.
This is not the last
Oh,
one.
moreover, it is 9th January. We are in August. Few more months left. It's no use going into it. Please come.
But kindly give.
No, nothing. The petitioner is aggrieved with the order of blacklisting the petitioner for a period of 3 years with effect from 9th January 23 and further deciding to forfeit the earnest money of rupees 9,000. Stop. The sheet anchor of the petitioner's submission is that the order of blacklisting was passed without hearing the petitioner. Stop. The petitioner has disclosed in the writ petition that the petitioner remained absent in his house because of treatment of his wife at Kolkata. Stop. The petitioner thereafter went to the postal authority to collect a copy of the notice, but the copy was not handed over to him on the explanation that the postal article was returned to the sender. Stop. The petitioner submits that there has been violation of principle of natural justice. Stop. The subdivisional officer, Bonga, has filed. Subdivisional officer, Bonga, has filed a report in the form of affidavit disclosing all documents, postal receipts to show that repeated efforts to serve the petitioner.
One of the reminder letter was received by his wife.
That is not endorsed.
Failed. Stop. One of the communications was, however, received by his wife.
No, my lord. Nothing has been received.
All right.
That has been reflected in my second letter, my lord.
On a perusal of the documents, it appears that most of the the maximum period of blacklisting is over, and the blacklisting is going to end. And the blacklisting period of blacklisting is going to end in early January 2026. Stuff. At such late stage, there is no the court is not inclined to decide the entire issue on merits. Stop. After the blacklisting period is over, the parties will take steps in the matter in accordance with law. The writ petition stands disposed. The exception to file to be taken on record. Next.
Number 11. Time for this.
Where is the petitioner? When you are there, the bank is not there. When the bank is there, the petitioner is not there. Show me. Your report is there already.
Yes, my lord, I have filed my report. And they are directed to take exception.
Exception served?
No, nothing has been served, my lord.
Nothing has been served. Dismiss for default. Record appearance.
12 and 13, my lord. Same.
12 and 13 also same. All right. Next.
My lord, is my application, my lord. Lord, I have challenged the show cause notice because it was based, my lord, completely reproduced from the forensic audit report. And, my lord, also a final order was reached, my lord, which was not served. Your lordship, my lord, took cognizance, my lord, of the matter on 7 July.
You are there? Reserve
Report-
Bank?
The
report
Bank
was
of
directed,
India
they did not file.
Yes, Your Lordship, I'm praying for a week's time, Your Lordship. Actually, the officer, the affidavit is ready. The officer has to come from the Ranchi branch to a format, Your Lordship. Kindly grant a week's time. We shall file it within a week, Your Lordship.
This is the 2024 matter.
7th
Ashwin,
July.
learned advocate representing the Bank of India seeks extension of time to file the report. Stop on such prayer. Time to file the report is extended till when?
Next week, any day, Your Lordship. By Tuesday, we shall file, Your Lordship.
All right. By Wednesday, 20th.
Yes, Your Lordship.
Stop.
Back with an
An
exception.
advance copy of the report shall be served upon the learned advocate representing the petitioner. Stop. It will be open for the petitioner to file exception to the same by 29th. Released on 1st of September.
Deeply grateful, Your Lordship. Lord, that's the monthly release day. Kindly, Lord, will keep it on the 2nd.
Monthly matters will taken up. Don't worry.
Yes, my lord, I appear for the state respondent.
Yes.
I'm appearing on behalf of the petitioner, my lord.
Yes.
The last occasion, there was a direction upon the authority to file a further report. But in the meanwhile, my lord, I got a document which is reveal the further sterling fact, my lord. Under the last occasion, my learned friend, my lord, filed a report. Kindly peruse that report first. Thereafter, my lord, I believe my learned friend will came up with is weapon with the further report, which my lord.
What is the issue?
Issue was the non-supply of OMR sheet.
All right.
In Purbo Mednipur district, my lord.
All right. Gram Panchayat Secretary appointment.
Yes, my lord.
2017.
Yes, my lord. In the year 2017, throughout the state, there was 1,151 posts. Among 1,151 posts, in Purbo Mednipur district, only 83 posts was there. I came up with today with that notification. Why they not, my lord? Kindly take this one.
You are relying upon newspaper report?
Yes, no, my lord. Advertisement, my lord.
Advertisement.
Yes, my lord. Because in our state, my lord,
Yes.
Karma Khetra and Karma Samstar, my lord, renovated, my lord, the newspaper for employment news.
Yes, yes.
My lord, kindly take, well, Purbo Mednipur, got it, my lord? My lord, kindly take my learned friend last report.
83, Shayok Executive.
Yes, my lord, 86. And what that says, my lord, kindly take my learned friend last report. 102 candidates were recommended and appointed. It is revealed from the RTI.
Which portion of the
My lord, kindly take all the non-paginated page 3.
All right, non-paginated page
yes,
3.
my lord, from the last 1, 2, 3, 4, 5, 6, 7, 8. Just 8 page before, because this is revealed through RTI reply. My lord, it is given to the petitioner itself. From RTI reply, my lord, kindly take entry 2. Got it, my lord?
What is the date of the reply?
My lord, 24th November 2023.
24th November 2023. Is it memo number 1363?
Yes, my lord.
Yes.
My lord, kindly take entry number 2.
Entry Shondip Kumar Acharya?
Yes. Shondip Kumar Tiwari, my lord.
Sandipon Tiwari.
Shondipon Tiwari, yes, my lord. Shondipon Tiwari.
Where is Shondipon Tiwari?
My lord, the above, my lord. My lord, got it, my lord. Above this one.
Shondipon Tiwari.
It is a RTI reply on the query of Shondipon Tiwari.
Yes.
They says how many candidates were recommended. Entry number 2. Got it, my lord? Entry number 2. Entry number 2. Entry number 2.
Yes, 102.
Got it, my lord?
Yes.
102 candidates were recommended and got appointment for the said recruitment process.
Is it
in respect of Purbo
Mednipur?
Yes, my lord. Because-
70. Sundipon Tiwari কোথায়? এইটা।
Where recommended and got appointment 12102.
my lord, out in respect of my lord 83 vacant post.
And there was no addendum or amendment.
There is nothing. But if that is there, my lord, kindly produce that. No OMR. Out 83 post vacant. 102 candidates recommended and appointed.
Yes, what
That's
is
the reason they have not kept this OMR sheet.
দিয়েছো, মালার একটা
Yes.
দিয়েছো তো? এটা আমার একটা। এটা পুরনো, মালার একটা।
This you handed over today?
Yes.
Handed on, give a one
This
copy.
was the
No, this is today it has been
Yes.
given.
then on 30th
Copy,
July.
copy.
I'm giving a copy.
Give a
Just hold on a bit, একটু 2 মিনিট দাঁড়ান না, এত তো বললেন।
Yes.
But how does it improve his situation? I don't know.
All right.
87, 107, 207, still it doesn't comes. Why? We are now got entire OMR sheet. We have annexed his one.
All
Right now, we are ready to produce whenever it is
How
required.
come the OMR sheet suddenly?
But let me, yes. That we also have explained.
Yes.
My lord, it was, the department was shifted, and that's why, as because of the shifting of the office, after your lordship's last order, I personally instructed the highest official, kindly do whatever needful, and let me say that whether it is at all available or not. Because 5 years has lapsed, he has came up from his one
Slumber.
fine morning slumber in after 5 years, whatever it may be. It is his choice. Now, his position, my lord, kindly take today's report. নাকি the last day's report এ লেখা ছিল? But the last day's report we said that his position is not coming within 102. Rather, if your lordship kindly takes up this page 5 of the present report, my lord. Sundipon Tiwari, my lord. Unreserved category.
Sundipon Tiwari, unreserved.
My lord, this is the OMR sheet. The next page.
Yes.
We are having the entire OMR sheet of all.
All right.
Now, my lord, as we have already produced in the last day, my lord, the 102 names, the last candidate, if your lordship kindly takes up page 13 of the last day's report, my lord.
Marks obtained. Written test 41, Viva Voci 9.2.
Yes, the last of the unreserved candidate scored 61 point. Well, let me just find it out. Well,
61 is not disclosed here.
Good, my lord.
He got 51.6.
Yes. And my lord, at page 22 of the last provisional assessment selected candidates, we have stated all the numbers
All right.
of each.
Yes.
There, at page number, the second page of that one, my lord, page 22, as it comes, I have marked it.
Yes.
Serial number 33.
Yes.
Raisha Roy.
She
obtained 64.17. That is the unreserved category, the last candidate. My lord.
All right, 64.17. But how many candidates did you recommend? On 102?
102, it appears, and my lord, it is the fact, my lord.
But
That I
then
cannot deny.
The advertisement was for 83 candidates.
So that was not within my knowledge, my lord. Neither this was questioned. Now this is for the first time questioning, my lord. Even if I take, my lord, for a moment, that yes, instead of 87, 101 has 2 has been given appointment. He is coming nowhere nearby. His score is about 254. The position is.
First, supply me the OMR sheet first.
The
yes, I am handing
this
it.
Supply it.
will give rise to further.
Yes. Well, I want to file
complications.
ballot exception to this report.
All right.
I believe someone will take
But
responsibility
my lord, the reason
with
what-
affidavit.
what was pointed out on the very first day that had this OMR sheet was not there, entire blame would have been that yes, only for the misplacing of the OMR sheet, my luck has opened.
They give the answer.
Now,
not test
this
or-
OMR sheet is there, my lord,
all of the
already
sudden
produce the
this OMR
entire
sheet
bundle
came.
before your lordship, my lord.
Yes, obviously, my lord, I will.
All right.
And this has been evaluated by my lord,
I want to
agency,
take
external
exception of
agency.
this. very
They
soon.
evaluate this OMR
But
sheet.
she's seen it, how did they prepare the OMR.
Acha.
And my lord,
A
on this
report
score, my lord, apart from coming before your lordship, my lord, this is what is happening before the entire newspapers and all. This is the marketing that is going on.
Kindly
This
see,
goes, my lord.
This is the OMR sheet. Where is my signature? Where is my signature? Where is
Check
my
up. Check up.
nothing?
Check up.
This is nothing.
Acha,
My
a
lord,
report
this fish
by
objects, my lord, when the matter is before your lordship.
it should not
nothing.
be. Please,
My lord,
do not-
either
I
they
have
should
no
come
idea.
have faith in the court, or else they have to go
I
before the my lord.
I have no idea.
please do not
I have
In
no
media
idea.
agency and everything.
I have
my
no
lord, this
idea.
is-
go to the media with the matters which are prejudice.
YouTube.
Let the media decide.
Before the court.
I have no idea. My lord, this is the OMR sheet, my lord. There is no signature, nothing.
Acha, report by the district
There
Panchayat
is
and
nothing.
Rural Development Officer, Purva Mednipur.
This is just
Signed on 31st July 25. Handed over in court today. Is taken on record. Stop.
What is
Copy
this?
of the same. Handed over to the learned advocate representing the petitioner in court. Stop. The petitioner seeks time to file exception to the same. Stop. Let exception be prepared and circulated by 22nd August. Released on 2nd of September.
My lord, at page itself, the signature appears 5.
My lord, this is
All
2
right.
pages, my lord. You supply it.
You
In
take
another
this to-
pages, my lord.
it फिर दे दूँ.
This is another page. This is another page. Nothing.
Next.
My lord, in this matter, I am appearing for state respondent, my lord.
My lord, I am appearing for the
2nd of September. Yes.
My lord, in this matter, my lord, because of the private parties dispute, my lord, we ask for demarcation by government armin, my lord. And that point has been clarified, my lord, on the last occasion, my lord, by the state by showing a notification dated 17th October 2007, my lord.
State.
My lord.
What
My
is
lord,
it?
what happened in this petition? I want to mix that submission. In page 13, paragraph 30, they made submission, my lord. Paragraph 30, my lord, that your petitioner states that this is where the dispute in public law comes in if the existing provisions of the law relating to survey land reforms and the Bengal Survey Act 1875 as extant after the order number 7123G 209/2092 dated the 24th December 1993. So this memo was there, but that has been overruled by another memo that has, my lord, published in 2007, my lord, 1993, and that has been overruled in 2003, my lord. In that memo, they didn't annex here, but they are trying to get privilege according that memo. In that memo, government notified that government, can be measured the private land as per the provision 56 of Land Reforms Act, my lord. So, my lord, what I made submission last occasion, that why we are saying that this is not maintainable. In Annexure P3, P12, that page 98, my lord, they made one application under 145. Why they have made that application? They have trying to take provisions of Memo 2007. 2007 has been overruled, my lord. In 2010, where one case has been filed by one petitioner, which has been set aside, my lord, that memo. So I will request my junior to show your lordship that 2 memos, that one is 2003 and one 2007, that is I have shown yesterday, last occasion, my lord. First 2003. In 2003, it has stated that they can get that provisions accordingly in law, stated in 56.
Where is the 2003 memo?
2004, your lordship, actually.
2004, my lord,
2004.
has published in 2004.
1993 and 2004 are both.
Oh, on the same page.
Yes, your
Yes.
এটা কি হয়েছে? হ্যাঁ। হ্যাঁ।
So in these petitions, they are trying to get that privilege, but they are making submissions by submitting one application under section 145, which has been, that provision has been implemented in 2007, which has been set aside by an order that passed by this honorable court in 2010. So now they can get that privilege under section 56 of Land Reforms Act, but that is not the correct process what they have followed, my lord. They have filed one application under 145 is not the correct procedure. That's why we have made that submission. This petition is not maintainable. They have to follow correct procedure. They have to make application on due course of law, which is permissible, my lord.
What does the petitioner want?
Beg your pardon, my lord.
What does the petitioner want? What is
Only
your
for
prayer?
demarcation.
You want government army to demarcate your private land.
Yes. Whether
Where
it is
it-
permissible or not.
It's not permissible.
That is
If
why, my lord,
One- 145 is not permitting that.
then my lord, the question put forward by your lordship, whether
Yes.
the Bengal Service Act still applicable in Bengal or not.
Right.
My lord will not find any answer given to that effect. Whether
Yes.
that is still in force in Bengal. If that be so, I'm entitled to get relief under this statute.
Show me the Land Reforms Act.
My
one.
lord, 56.
That is Land Reforms Act relates to, my lord, any demarcation in the government property is involved.
Section 56.
If the government property is involved, Land Reforms Act, the Amin has the power and the BLR has the power to jurisdiction. The only subject to question what my learned senior friend is submitting is that the property which is can be measured by the Amin. But Bengal Services categorically mentioned that what are the spaces the government can assist for the purpose of demarcation.
This is also not private land. Survey Act is not a private land.
Every act, every plot, there is no restriction.
Section 3.
কেন এখানেই তো আছে আমার বেঙ্গল সার্ভে অ্যাক্ট তো এখানে ছিল না খাবার করা কোথায়
Section 56 of the Land Reforms Act.
Yes, my lord.
You have it?
Just now, my lord. Land Reforms Act আছে
Hmm.
56. Under this act, my lord, your lord shall find may at any time enter land not a dwelling house. Such officer or the person considered necessary to make a survey, measurement thereof, and other acts is considered to be necessary for carrying out his duties under this act. So, under the original Land Reforms Act, that is precisely, my lord, my submission is that under the Land Reforms Act, my lord will not find there is any demarcation for the purpose of individuals. What must be the government? Because your lordship, government land
and the private land, if the government land can be demarcated, my lord. Therefore, my lord, whether this provision cannot be subject to correction, my lord, cannot be private subject, and that is why precisely, my lord, the only question I can put forward for your lordship, if that act is still valid, I am entitled or not. That answer is not coming before your lordship till today. Whether
I'm not
this
getting.
act is the simple question put forward by your lordship. After that, we can argue on the merit,
Yes.
whether it is there or not. I have raised the question and supported by coordinated judgment. Yes, this act is valid. Now the state government should come forward and before your lordship.
No,
say,
but
no,
145,
valid.
they made application under section 145. They
145 is wrongly made. What will
Wrongly,
be the
my lord,
proper
that-
provision? You say your officer has to say what will be the proper provision. Why is this answer not coming?
My lord, any public can come before the government official by paying their, but we are not own can survey. If they are making that prayer before us by process that yes, we need that survey, we can. My lord,
How
that is,
can you?
but only in this petition, my lord, in this petition, they are trying to take effects of that of that annexures P3,
Madam,
P12. That is not right, my lord.
Madam, who is the officer who is instructing you? Who is the officer
My lord,
instructing
BLRO,
you?
I am taking instruction from BLRO.
From?
BLRO, my lord.
BLRO?
My lord.
Which BLRO? Which
DLRO, DLRO.
BLRO or DLRO?
DLRO, my lord. DLRO, DM is instructing me.
From BLRO to DLRO and to DM.
DM also, because some questions they are also clarifying me.
Where is the answer? Whether
next-
the Bengal Survey Act is still valid or not? What is the answer to this query?
Only this thing. After that, my lord can get into and whether my application is maintainable on that will be considered later. My lord, the primary question put forward by your lordship is only whether this statute is applicable or not.
My lord, kindly fix this matter. Tomorrow I will clarify this question answer.
This is going on for so
My
many
lord,
days.
my lord, I am praying before your lordship.
Section 3, if lordship.
Which one?
Others.
Yes, the act is here.
Yes. Section 3.
If your lordship can.
Yes.
The state government may, by order of the state government may. The state government may, whenever it shall think fit, order that survey shall be made of the land situated in the district or in the part of the district or in the specified tract of the country, that the boundaries of states, tenure, mojas, fail be demarcated on the land so we sought. That's not, does not mean that that is the private lands. That is at the point of time, there was no map, there is no mojas. For that reason, my lord, the said act came into force.
So this is your case that 1875 Act is not valid.
Not applicable.
Not applicable. Then what will be the proper law under which a private party can go?
Civil suit is the.
That means the civil suit will be the only forum.
That is in this case, my lord.
If that is so, my lord, that is why, my lord, precisely I am asking whether this act is available or not.
I'm relying to judgment of the Supreme Court. The civil suit is.
No, civil suit is applicable, that it goes without saying. Is there any other specific law under which this can be done?
No.
My lord, kindly fix this matter. Tomorrow I will clarify only this part, my lord.
May demarcate, my lord.
No, that is different.
My lord, my lord. My lord, I cannot.
What is followability? That is the question which also troubling us.
That civil suit, there is no bar. Absolutely all right. But apart from that, if the Bengal Service Act under which he can get it, then the relief will be immediately he can get relief.
Bengal Service Act not applicable because, my lord, there is for the, my lord, state government has framed the act for the demarcation of the map.
That is different, but whether this act is
this
still
act was adopted under the Governments of India Act.
Show me.
Yes, the act either from the very beginning.
Which portion?
Bengal Act. No, Survey Act. At the beginning, my lord, your lordship find.
Yes.
Bengal Tenancy Act came into force, my lord.
Amended by Act of 1903, my lord will find. Adopted.
903.
After adoption.
19.
Government of India adoption India Order 1937. In the Indian independence order,
Which portion? Which portion?
at the beginning, my lord.
Beginning, the preamble is there.
After that, my lord.
Short title is there. Interpretation clause is there.
6th October, may I hand over a copy? Well, ওটা যদি থাকে, may I find it out, because it will not tally with my, না শুধু only একটুকু দিলেই হবে।
1903 is a repeal by section 4 art schedule of the amending at 1903 is
repeal.
Show me that repeal.
It's a Joshua Kidding.
It's not here, isn't it?
It is Bengal, Bihar, and part of the Odisha.
Well, it will find at the top. Initially, it is Government of India Act or India Order. After post-amendment order was acted.
When is the date of repeal?
Repealing.
When is the date of repeal?
But a short title, if you kindly see, my lord, commencement, short title.
Yes, this may call the Bengal Survey Act 1875.
And thereafter, my lord, Bengal Tenancy Act came into force.
1903.
And it was March.
It's amended by such and such Bengal, the Government of India Act.
Bengal Tenancy Act came into
the
force.
adaptation of what? Still a confusion is there.
Bengal Tenancy Act, my lord, kindly see, my lord, that came into force, my lord, if you lordship.
You find out the specific provision. Please come.
Present provision, my lord, section 9B.
My lord, I could not understand subject to question, my lord, whether the state is not
repeated.
Yes.
My lord, kindly
Despite
fix this matter.
repeated opportunities granted to the learned advocate representing the state respondents to obtain specific instruction as to whether the Bengal Survey Act, 1875 is still in existence or not, there is no answer to such query of the court. Stop. The learned advocate representing the state respondents is directed to obtain instruction from the Commissioner of Land Reforms.
Director of Land Reforms.
Director of Land Reforms. To obtain specific instruction as to whether the Bengal Survey Act, 1875 still survives or not. Stop.
And it is applicable by the for private land.
The director shall specifically instruct as to whether instruct if the act is still in existence, whether the same can be applied for demarcation of private lands, and in the event the same is not in existence, then the proper provision of law under which a private party can approach the authority for demarcation of private land.
Grateful to your lordship.
Relist 25th August.
Grateful to your lordship. May I get back the copy of the which I have lastly handed over to your lordship?
You want this back?
Oh, no, not that one. That's subsequent last.
The instruction forwarded by the subdivisional officer Jangipur, Murshidabad. এটাই দিল তো না আরেকটা কিছু দিল? এটাই be written with the record.
Grateful to your lordship for standing.
For the respondent number 8.
I'm appearing on behalf of the respondent number 2, Your Lordship. As per Your Lordship's last order, Lordship, I am filing the affidavit, Your Lordship.
Doctor, I'm for the petitioner. Lordship,
Okay.
first, this is the writ petition challenging the selection of the private respondent for the post of, Lordship, the defense counsel in the concerned court. Now, Lordship, kindly come page 27. This is the selection procedure published by the State Legal Services Authority. After due publicity, including public notice, Lordship, got it, page 27 of my writ petition. After due publicity, including public notice, the application will be invited and a fair and transparent comparative examination process shall be adopted by the DLSA under the guidance, Lordship, kindly mark this portion, under the guidance of State Legal Services Authority. Legal aid defense counsel shall be engaged on contractual basis in each place district initially for a period of 2 years with a stipulated of extension of the earlier basis on the satisfactory performance. The performance of each human resources shall be assessed on every 6 months, such and such. Now, Lordship, the Chief Legal Aid Defense Counsel, Deputy Chief Legal Aid Defense Counsel, Assistant, Lordship, these are the posts. Now, Lordship, kindly come. This is the notification. Lordship, this notification was issued by the State Legal Services Authority. Lordship, kindly come. The post is page 35, district-wise post.
Yes.
District-wise post. This is, we are concerned about the Birbhum. Lordship, the chief, we are not concerned. Defense, Deputy Legal Aid Defense Counsel, that is 2. Number of post is 2. Now, Lordship, in terms of this notification, Lordship, I applied for the Defense Counsel, Deputy Defense Counsel, that is page 41. This is my, Lordship, the application. This is my letter issued in favor of the petitioner for assessment, to appear in the assessment. Page 41. Lordship, the district judge has issued this letter. And Lordship, kindly come page 42. Who were the applicant, Lordship, in the said process? That is serial number 2, the petitioner number 2, that is Ardhendu Shekhar Mondol was the petitioner. And Lordship, kindly come serial number 5, the Nasiruzzaman, who is the private respondent number 9. He also appeared in this initial notification. Now, Lordship, kindly come page 43. Time of examination. Written examination was held. Lordship, for page 43, time of examination, that is 6 November 22 from 12 noon to 1 p.m. Now, Lordship, kindly come page 44. This is the vivacity test. This petitioner also called in the vivacity test. Now, petitioner got the first position. Page 45.
Yes.
Now, kindly come mark this date. Thus, this panel was published on 8th February 2023. Now, prior to 8th February 2023, the district level authority issued a notification. Now, first, my challenge before your Lordship, that district level authority, in terms of these guidelines or the rules, according to the report, this report, that district level authority will monitor this recruitment process. This recruitment process has been published and everything done under the instance of the district level authority. Whether he has a specific, my grounds, I have stated in the paragraph, the district level authority has no authority to initiate this recruitment process.
The second one, the second recruitment process.
Second recruitment process. And second recruitment process was published on 6th January 2023, prior to, Lordship, the publication of the panel. So, Lordship, my first grounds of preliminary objection, the maintainability of the writ petition, that I have been put in bar, that I have participated in the second recruitment process, that will cannot stand in the way, because this recruitment process, first recruitment process completed after the publication of second notification. That is, list was published, panel was published on 8th February 2023. This notification was issued on 6th January 2020, prior to publication of the panel.
Yes, but then you participated in the second process and you became unsuccessful. Now you are coming around and challenging it.
No, I have challenged that first recruitment process has not been concluded, has not been cancelled. On the contrary, second recruitment process initiated by the
Then
district.
you should have come at the time of publication of the notification, 6th of January 23, when it was published.
The process, Lordship, the decision-making process of the second recruitment process is without jurisdiction.
Yes.
Now, Lordship, kindly, this is the, Lordship, the panel was published. I am not in the panel. That is the admitted fact.
Then why will the
Now,
court
Lord,
look into all
kindly
these
come the
things?
guideline. Kindly come the guidelines. These guidelines has been relied in this report. This guidelines has been starts from page 51, Legal Aid Defense Council Scheme 22.
One of the writ petition?
My writ petition, I have annexed the guideline.
Yes.
Selection procedure.
This 2022, for 2023.
Yes.
Page 57. Lordship, got it?
Yes.
Now, before this guideline, Lordship, kindly hear me for a moment. That second recruitment notification has been issued, called for the viability test. No written test has been held. So, Lordship, here is the first ground. Second ground is, without any conducting written test, this recruitment process has been, decision-making process is totally contrary to these guidelines. Kindly come, paragraph 4, clause 4, page 57. After due publicity, including public notice, application will be invited. A fair and transparent and competitive selection process shall be adopted by the district level selection test under the guidance of SLSA. Lordship, kindly see, this is the word, under the guidance of SLSA. Legal Aid Defense Councils shall be engaged on contract basis in each place district initially for a period of 2 years with a stipulated of extension on yearly basis subject to the satisfactory performance. The performance of every human resource shall be assessed every 6 months of SLSA in consultation with the DLSA concerned. The selection of Chief Legal Aid Defense Counsel, Deputy Chief Legal Aid Defense Counsel, Assistant Legal Aid Defense Counsels will be purely based on merit, taking into account the knowledge, skills, practice, and experience of the candidate. Based on merit. Lordship, the selection shall be carried on by the selection committee under the chairmanship of the principal district and session judge, chairman DLSA, as envisaged in NALSA Free and Competent Legal Services Regulation 2010, subject to final approval by the executive chairman SLSA. The selection committee, at least 3 senior most judicial officers posted at headquarters dealing with mainly with the criminal cases, preferably sessions cases, shall be included. No persons with conflict of interest shall be part of the selection process. After the approval of the executive chairman SLSA, Lordship, the engagement contract shall be executed between the secretary, DLSA, and the persons who engage. So after the approval of the executive chairman, State Legal Services Authority, Lordship, this is the approval is required. Now, Lordship, kindly come to the report. Report which has been handed over today. Paragraph 6. Very relevant. Paragraph 6. I state, subsequently, another notification being advertisement number 6 January 2023 was issued by the Secretary District Level Service Authority, Birbhum, and the applications were invited for contractual full-time engagement to the post of Deputy Chief Legal Aid Services Counsel and had been created under the Legal Aid Defense Council System Scheme 22, Lordship, which I have just now referred. It will be based on the merit, and Lordship, under the SLSA. It will be done under the SLSA and approval of the SLSA. The office of the respondent number 2, that is the SLSA, is not in CC of any document regarding the genesis of the subsequent notification advertisement dated 6 January 2023. So SLSA had no knowledge of the recruitment process, which is started on 6 January 2023. It is totally contrary to the scheme of 22. It has to be conducted under the supervision of the State Legal Services Authority.
What does paragraph 7 say?
I state that
participate in the selection process. Which selection process?
the
23.
second selection process.
Second selection process.
And it is admitted that I was first in the first selection process. Let's say my contention is, when the now kindly comes second selection process, whether the first selection process has been cancelled or not. It has not been cancelled. Let's say kindly come the second notification. Let's say kindly come the second recruitment process, page 46, P4, which was issued by the Secretary District Level Services Authority. In view of the direction of the Honorable Executive Chairman, State Legal Services Authority, West Bengal, by such and such, dated 3rd January 2023, it is hereby notified that the Office of Legal Aid Defense Council, Birbhum, under the District Legal Services Authority, Birbhum, is inviting application from the eligible candidates, preferably residents of Birbhum district, for one vacant post of the Chief Legal Aid Defense Council and for 2 vacant posts of Deputy Chief Legal Aid Defense Council. The learned retired district judge, learned retired additional district judge, and learned advocate may apply for the engagement for the post of full-time Chief Legal Aid Defense Counsel. The learned retired public prosecutor and the learned advocates who may apply for engagement for the post of
1 minute. You are representing Salsa.
Lordship.
And are you representing DLSA also?
No, it's not.
Who is representing DLSA? 4, 5, nobody is representing. Just 6.
Secondly, Lord, so I have also served because Mr.
Who was appearing?
Dipanjan appeared.
State.
Yes, Dipanjan appeared. Lord, so I have on the basis of your Lordship direction, I have served the district level. Lord, so kindly see my second affidavit of service. State as well as district level authority also I have served.
Yes, item delivered. 6545. No, I can understand 2 recruitment processes initiated by 2 different bodies, one by SLSA, one by DLSA.
Yes. So DLSA has no authority under the scheme.
Participated in both.
Yes. Before the merit list came out, Lordship, he appeared in the second subsequent proceedings.
But then there was no bar for him to appear. Was there a bar? There was no bar. He could have appeared.
Lordship, when he is appearing in the subsequent process, Your Lordship.
By a different authority, not by the same authority.
No, Your Lordship.
Then, where is the bar? There is absolutely no bar.
But the post is same, Your Lordship. The post which he is applying for, it is same, Your Lordship.
How could DLSA come up with a notification?
That document we do not have. I have filed the affidavit on that basis.
That you have filed, but did you call for records from DLSA?
Lordship, we have tried to find out the records. Your Lordship, there is no records we could find out.
Well, that's very strange. If the DLSA doesn't have records, then how could the recruitment process be conducted?
And the recruitment has been given to certain persons already. They're already acting.
How?
I don't know. We are receiving salary also, the honorarium also every month.
Then this is very strange. Is the district judge Birbhum a party over here?
Also, district level selection, yes.
No.
No, district level authority has been.
District magistrate is a
Some
party, but
authority
district
shall
judge is not a party.
It doesn't have anything to do over here. DM cannot help.
No, chairman district level service authority is a party. Secretary district legal service authority is a party. And district magistrate is also a party.
আসুন তো দেখি।
Also kindly kind of steps lordship so that the further remuneration cannot be disbursed.
You are not doing any service. Somebody is serving and you want his remuneration, and that will be also contractual.
This is without having a jurisdiction. This is
How do you
absolutely-
know? This is what the court wants to know.
And this report clear that their state level authority has no document because it is pertinent to
Malad,
mention.
it's a contractual job for 2 years, and nearly 1 year is already over. For-
None appears on behalf of the District Legal Services Authority.
দুটো অথরিটি কি করে আলাদা আলাদা করে?
বীরভূম। Stop. Let notice be served upon the district judge, Birbhum, intimating that the matter will appear in the list on 25th August 2025. Stop. The district judge shall file a report disclosing all documents in connection with the recruitment process of Legal Aid Defense Counsel, published by the Secretary, DLSA Birbhum Shiuri, Vide advertisement number 01/DLSA/Birbhum, dated 6th January 2023.
As well as the previous one also, Malad, then we can know better.
No, previous one SLSA is here. Previous one is not by DLSA. Achha. Specific instruction shall be forwarded by the district judge as to whether the said advertisement was published after that the কি বললাম specific as to whether the said advertisement, whether the engagement in terms of the said advertisement will be over and above the engagement to be made by SLSA West Bengal in terms of the advertisement number 3233/SLSA-21/2022, dated 25th August 2022. Stop. Tell me one thing, what happened to this 25th August 22, the notification that you published in 25, the petitioner secured the first position. Why is the engagement not given to him?
District.
Lordship, that knowledge also we do not have. Why the recruitment process was not done?
You are for SLSA, madam.
Lordship.
You cannot be claim ignorance of all these things. You have to say, what is the fate of this?
Lordship, I'll take instruction according to the new Lordship.
It should have been reflected in the affidavit, the report that you have filed. Have you followed? What is the query of the court?
Lordship.
There was an advertisement. There must be an end to an advertisement.
Lordship.
Where is the end?
That was not, that document we do not have in our files, so Lordship. That is what instruction I have received. I'll again inquire on the same, Lordship.
Malad, on the earlier occasion, I handed up a particular order by the Honorable Division Bench, where it stated that Your Lordship correctly observed that it is not regard to Birbhum, but the Chief Justice was the chairman in that committee and it
Yes.
cancelled the 2022 advertisement.
Has this
Whether
selection
that
process
has
been
reflection
scrapped?
of Birbhum, regarding Birbhum, that's exactly what your Lordship wanted to know.
Whether it has been scrapped or not?
It has been, this was in respect of only one district. It's stated out here, but this is the
That
this
would
order.
help.
I'll come back if there's anything else on the matter. Whether everything has been
The
scrapped. or
learned
not.
advocate representing SLSA shall take specific instruction
A judgment
with regard to the fate of the selection process initiated via the aforesaid advertisement dated 25th August 2022. There must be something to say that this has ended, this has been scrapped, we are not proceeding. Something should be there.
May I read out this particular order, my lord?
No, but then is it?
I just read out, my lord. It's only 8-9 lines. In order to ascertain the steps taken by the State Legal Services Authority with regard to the writ petitions for the post of Chief Legal and Defense Counsel for the District of Howrah, we directed the SLSA to produce the original record. It appears from the original records. So, my lord, they are having it, that there is no recommendation by the selection committee of these candidates. The matter
That
was...
means the process went on till its finality?
Yes. The matter was placed before the then executive... Your Lordship, can you hear me for a moment? Executive Chairman, presently the Honorable, the Chief Justice of this court.
Yes.
The present Honorable, the Chief Justice considered the report and recommended the issuance of fresh advertisement for the said post. The SLSA was of the view that none of the candidates could fulfill the NLSA guidelines.
Right.
In view of the fact, it is a very...
Let the authority say that the petitioner...
Yes, I do not know. She doesn't even know about this.
How can? Who is instructing you?
Lordship, the present secretary.
I can hand up a copy of the order, my lord, itself.
You
I'll take
inquire,
appropriate instruction. Your Lord.
otherwise, things will go wrong. Somebody is there in service for 1 year.
And it's a contractual service for 2 years, man. And every year it's only a...
All right, come. You also take instruction as to whether this selection process has been scrapped or not.
No, Lordship, because Lordship, this subsequent...
Because there is an order of the Chief Justice, it says.
That is the I have already collected the order. This is in respect of Howrah only. And because in the Howrah,
all districts,
candidate who participated in the selection, they could not fulfill the criteria.
This is what the court wants to know, whether you fulfilled or not. But
Lordship, first of all, Lordship, when they have issued the second notification, ought to have been mentioned that in cancellation of the earlier notification, this notification has been issued. Nothing has been done.
Let us see. Yes. Next.
Malad, can I get a copy from my learned friend out here?
Certainly, circulate copies.
Lordship, I have served him the copy.
This matter kindly short date, Lordship. This is a...
Yes.
25th.
Good.
My lord, I beg to appear on for the statement.
What is the matter?
My lord, one of the petitioners is an employee of Department of Post. There is an allegation of defalcation of money. When I got bail, I was suspended. I got bail from the Honorable Apex Court and I have been reinstated. A particular property that has been, an agreement has been made by a developer for developing the property. All of a sudden, if your lordship kindly turns to last page, which is under challenge.
Which is?
Which is under challenge.
108?
108, madam.
Copy of the additional such and such for?
Not I have given a type.
Sale of properties. Yes.
This is under challenge. Why? My lord.
What is there? There is nothing to challenge over here.
Yes, my lord. My lord, the authority has
what stop?
That not to alienate the any property of the petitioner. And what is the basis of issuing such a notice?
An instruction?
Yes, I have this one instruction from the ADM or DLLR.
What does it say?
But kindly see page, my lord, last page. Page 3, my lord. Whatever step we have taken on the basis of that letter, my lord. This letter has been issued by the Postal Department. I read the letter, my lord.
Give a copy to learned friend so that he can also follow what is there.
Yes. But, this is in edit.
Where are the case details?
But,
The petitioner has been found to be involved in misappropriation of funds.
yes, they have also admitted in their writ petition.
That I have stated.
They have stated in their writ
There
petition.
is no doubt.
In the, where is the case details? What happened to the misappropriation case?
That is pending, my lord. Now,
Where?
departmental proceeding has been initiated, my lord. That has been mentioned, my lord.
Please come. The petitioner is aggrieved by the communication made by the District Registrar, South 24 Parganas, on 13th June 2022, requesting the Inspector General of Registration and Commissioner of Stamp Revenue, West Bengal, to stop alienation/sale of properties held by the petitioner and 4 others, including their families. Stop. Learned advocate representing the state respondent submits that the said notice was issued pursuant to the direction passed by the Superintendent, Baruipur Division,
Postal Department.
Postal Department, that the petitioner has been found to be involved with misappropriation of office cash amounting to rupees 1 crore during remittance of office cash from Baruipur Head Post Office to the State Bank of India Baruipur branch. Stop. State Bank of India Baruipur branch. The petitioner, then being the treasurer within bracket cash 1, the petitioner was serving as the treasurer cash 1 Baruipur Head Post Office. Stop. He has since been suspended. The order of the order requesting stay of alienation/sale of the petitioner's properties, petitioners and his family's properties, had to be passed for recovery of the government loss. Stop. The Department of Posts incurred huge loss because of the fraud committed by the petitioner. Stop. It has been the petitioner admits that the proceeding for misappropriation of fund is still pending consideration.
Baruipur case has also been initiated, my lord.
Give. A criminal case being Baruipur PS case number 732/22 dated 26th April 2022 under section 409 IPC is also pending consideration. Stop paragraph. Under such circumstances, the impugned order appears to have been passed. Stop. The court is not inclined to interfere with the same. Stop. It will be open for the petitioner to approach the competent forum for relief in accordance with law if so advised, disposed.
May I make one humble claim? In addition to that, whatever my lord has said, my lord, so lordship kindly grant me leave to challenge the order by which the additional district magistrate had issued the notice, my lord. The challenge, the notice that has been produced by my learned friend. So what
Yes.
says it, the liberty be granted to.
Liberty to take steps in accordance with law if you are aggrieved with anything.
Much
Lord, I am appearing for the petitioner.
My lord, I appear for the state, my lord. My lord, I apologize for not being in court, but there's a report that has been filed by the judicial department. My junior is there. He shall hand over the report. My lord will see the non-paginated page 19. This is a case.
What is the petitioner's case?
My lord, I am a life convict. For the last 31 years, I am in custody.
Yes.
My lord, my lord, claim, my lord, that I have to be, my lord, released prematurely under section 432 and 433A of CRPC.
Let me
My lord,
see. You are 1 minute. What is your name?
Babulal Yadav, my lord.
Babulal Yadav. What does it say? Babulal Yadav, along with his brothers, entered such and such. He can not only it has not been recommended. It cannot be done.
It has been recommended.
While it sees it has not been
My
recommended.
lord, this is the judicial department's minutes.
And see, my lord, petitioner Babulal Jadhav, my lord, this was a report, my lord, placed, my lord, by the competent authority, the State Sentence Review Board. That petitioner Babulal Jadhav is a life convict who is currently, my lord, under.
What's the date of what you are reading?
My lord, this is the report, my lord, submitted, my lord, by the state authority, my lord,
submitting a
pursuant to
report
the
of
order
5th
dated.
December 2024. Subsequently, order has been passed on 9th.
Yes, I see 19th December's report over here. It says it cannot be done.
No. It was, my lord, your lordship, my lord, kindly see, my lord, page number 3 of this report.
No, thereafter the department has rejected it.
How, my lord? That is why, my lord, I am coming, my lord, this honorable court, my lord, for, my lord, ventilate, my lord, my grievance. That after 31 years, my lord, there are so many judgments of the honorable this court and, my lord, the honorable apex court.
No, as a matter of right, are you required to be released? You are a life convict.
No, right.
The authority says that there is you may be a matter of concern to the society. Your release.
That is why, my lord, I am saying, my lord, that after 31 years, my lord, but moreover, my lord, I, along with my brother, my lord, was convicted and sentenced to life. My lord, in the year 2012, my lord, my brother was prematurely released. I am, my lord, the only person, my lord, detained in custody, my lord, for the last.
What can be done?
Your lordship, my lord, kindly see, my lord.
No, nothing doing.
My lord, your lordship, my lord, kindly see, my lord, my lord, submission. Then, my lord, your lordship, my lord, kindly take, my lord, your lordship, my lord, kindly see that the Babulal Jadhav, your lordship, my lord, kindly see page number 3 of the.
I have seen it.
And, my lord, where is that? My lord, this was not served upon me.
The petitioner is a life convict. Stop.
It was not served upon me.
He prays for premature release. Stop. His case, his prayer was considered by the
Judicial department, my lord.
State Sentence Review Board on 2nd September 2022, and his premature release was recommended. Stop. Thereafter, the minutes of the review board was forwarded to the judicial department, and
my lord, there was an inspection report, and at the meeting held
And the judicial department has noticed that the convict not only committed a premeditated murder of the victim, but also organized the same and committed breach of trust of his former employee. Stop. He is 51 years of age and his capacity to commit further crime may still be a concern for the society. Stop. The prayer for premature release has been rejected. Stop. Next. The
May I get a copy, my lord, of this, my lord?
My lord, I am not.
First of all, my lord, the report is
The-
wrong, my lord, on this,
as
that I
the-
have not committed, my lord, this murder. I was along with my brother.
as the judicial department has not recommended the case of the petitioner for premature release, accordingly, no order in favor of the petitioner can be passed in the instant writ petition. The writ petition fails and is hereby dismissed.
Lord, may I get a copy, my lord, of this, my lord, judicial
Yes,
department?
yes. Whatever is there, I have recorded in the order
No,
sheet.
my lord, I was,
I have recorded in the order sheet.
I was not served with the copy. That's why.
Give a copy, but then I have
There was
recorded
no
in the order
direction to
sheet.
serve upon him, my lord.
Yes, next.
Obliged, my lord.
In item number 20, I am appearing for the petitioner.
Yes,
My lord, I'm appearing for Reserve Bank of India.
All right.
Sir, back to appear on behalf of the Indian Bank. Let's see, your lordship, last directions. There was a direction to hand over physical possession by 1st of August. The petitioner reluctant to, thereafter we send him mail, thereby reminding the order of the honorable court. Thereafter, much emphasis on the part of the bank, they turned off, take physical possession, bank has handed over the physical possession. Thereafter, he crop up with new stories.
Let him place his case.
Lordship.
There is
Well,
an application.
on last occasion, matter came up before your lordship on 16th of July, my lord. Your lordship will find from your lordship's order on that date, it was stated on behalf of the petitioner that the petitioner himself is ill, and subsequently, my lord, he had undergone a serious cardiac operation, my lord. Not only that, my lord, his eldest son became ill also. As a result thereof, a little bit delay was caused for compliance of your lordship's order.
All right.
And ultimately, my lord, he authorized his eldest son for
Taking
interacting with the bank, my lord. And he was present there on that date, my lord. What bank did, my lord, there were 2 entrances in the property. Out of 2, key in respect of only 1 entrance was given to the petitioner's representative. Another is lying vacant, my lord. No.
Another is lying vacant means?
My lord, there is no, as we know, my lord, there no key was given, and from the said entrance, outsiders are entering into the said property. Not
lock it. Now you've taken possession.
because, my lord, what happened, my lord? I'm saying, I have given a note. The representative had given a note because bank had not demarcated. I told them, kindly demarcate the land so that I can lock it or not, whatever. They had not done it. That has been given, my lord. Moreover, my lord, within the premises, there were 2 or 3 rooms, my lord. Within that, earlier I have also told, my lord, that electricity consumption was going on. They failed to justify that, whether that line, that connection is justified or not, or whether it is a pilferage. Till that, my lord, they have not given. And my lord, what is the exact position of the latest paid up tax to the authority? That has not been given, my lord. But as a result thereof, outsiders are taking access inside the property, my lord.
Is it a vacant land?
A large portion of that is a vacant land, not a building, my lord.
All right. What is the area?
Area, as they have mentioned, my lord, 2 katas, 4 chotak, etc.
All right. And the structure is what is the area of the structure?
That exactly I can say.
How much is the vacant portion? Is the structure
vacant portion
locked?
is large portion, my lord.
Is the structure locked?
My lord, structure is lying vacant, my lord.
My lord, structure, is it locked or not? Does it have a lock?
No, my lord, it is lying. There is no padlock within that structure, my lord, as we find.
The structure doesn't have gates or doors or nothing which can be locked?
No, my lord, no separate gate is there. Anybody can take entry. There is a vacant land. After that, there is a structure, my lord. At
And
the
in
side,
the structure, there is no gate.
no gate, no separate gate to protect it. There are only doors are there.
So you lock the door at least so that nobody can enter.
My lord, it was endeavored by the client, my lord. Subsequently, that has been broken.
Who has broken it?
That I cannot say, my lord. It was.
Suppose somebody has broken it after you have taken possession, then you report to the police. They will take steps. Why you run after the bank?
Because, my lord, they have not given the access. Your lordship will find, kindly take up. I filed an application, my lord.
Yes.
My lord, for seeking for appropriate order. If your lordship kindly comes to page 26 of my application.
Yes.
I have already served to them. Your lordship will find this alleged certificate of sale, which for the first time they handed over to me within the court on 9th of July 2025. And according to them, it is prepared on 16th June 2022. Prior to that, nothing was given. Your lordship will find, my lord,
2 kathas, 4 chataks, and 36 square feet.
Square feet, my lord. Lordship kindly see LR Khotian number
Yes.
1133 and 1463.
Mm.
Your lordship kindly turn to this next page, my lord. 1133. These information was obtained from Bhumi Sanskar Udbastutran, my lord, land and land house. And then page 28, my lord, your lordship will find in respect of Khotian 1133, one Molay Kumar Kole's name is apparent. And my lord, your lordship will find.
Molay Kumar Kole possibly was the borrower, was the earlier.
No, he's not the borrower. Borrower's name is Siddhartha Patra.
Maybe somebody else.
Lordship, kindly once again take up page 26, my lord.
26.
Yes, at the boundary.
Yes.
On the north by the property Molay Kole. And this is the same. Unless it is demarcated by the bank, it is very difficult, my lord. They are claiming on earlier occasion, my lord, on the first occasion when we visited with the bank officers, we have our pen drive, my lord. Outsiders came and raised their objection. Earlier we told before your lordship. And the next name, your lordship, at south, Shumali Kole. His name is also apparent in respect of the Khotian number 1463. Unless it is demarcated, it is very difficult, my lord, for take position, my lord. Merely giving a key, my lord, it is, my lord, your lordship kindly appreciate it is nothing but an idle formality on part of the bank.
Right. Yes, very well then.
My lord, as a result thereof, they have, my lord, trying to show that they have discharged their duties, my lord. And my lord, my specific allegation in the writ petition was that under erroneous information, they had published the notice, my lord. Notice of auction twice, not once, my lord. And subsequently, before the ombudsman, it was their statement that was.
All right, wait, just wait. LR Khotian numbers. Now the bank has handed over property.
Let's say bank handed over property. Kindly see the allegations are all bolstered up. He is saying the land is totally without boundaries. Surrounded by the boundaries.
Is the land demarcated?
Already demarcated.
No demarcation. Let them show, my lord.
Interest gate is there. Locking key was there. We handed over the key.
Let them show the measurement.
Now he has come forward with
no,
the
this is
and it is butted and bounded on all four sides.
Yes.
It is, there is a boundary on all four sides.
Boundary wall is there.
Boundary wall is there.
My lord, boundary wall, they are claiming.
Of the boundary was fenced by the petitioner.
That is incorrect, my lord. How can it be, my lord? They have given position according to them on last few days.
Considering their pair,
last few days.
Come forward with new stories. Now they want to let the bank prepare the multi-story.
My lord, in the writ petition, it was told, my lord.
Listen, this is not the submission. Please do not put words in the mouth of the petitioner.
The conduct.
Your conduct is also not very fair.
Lordship.
The sale certificate is dated 22.
Yes.
And here in 25, after getting a...
respect, subject to Lordship kind consideration.
I do not want to hear anything.
Yes.
You have handed over possession, you say.
Yes.
And there is boundary on all four sides. Show me that there is boundary.
We have also put there the guard. The guard photographs is also there.
Well,
since they are reluctant to take physical.
My lord, we repeatedly requested the bank officers to.
Please, I have.
Have you checked up? whether there is boundary wall or not.
My lord,
It
there is
says
a
that-
boundary wall, but they failed to justify the measurement therein. We requested kindly show us the measurement.
Kindly see page 49 on
One
what
minute.
basis you have participated.
There is boundary on all four
A
sides.
portion is broken, my lord. Someone is entering. I don't know, my lord, whether
If you do not take possession of the property, the other portions will also go. So now the property is yours. Please take care of it. It is your property. And there is a boundary wall, there is a gate, there is an iron gate, it can be seen.
at the front another gate is lying open, another entrance is lying open. They are
Put
from
a lock over there.
no gate is there, my lord. There,
You construct a gate over there.
local
You never had the possession.
my lord, local people are saying, my lord, kindly appreciate. Local people are saying this that is not of yours, and we requested the bank to let us know how much is of our portion. Bank is declining that. They are not showing the exact demarcation.
No, he says that it's demarcated on all four sides.
My lord, absolutely, my lord. Wrong, my lord. On repeated occasion, we requested, let them show, my lord, from their own.
On what basis he has participated? If she is so, kindly see page 49. Terms and condition of auction notice. Let's kindly see page 49 at the bottom.
No, you'll say as it is.
As it
as
is,
is
my
he
lord,
has
on
to make
that
an
point,
inspection of the same.
basis.
He has to make the
That's all.
inspection of the same.
my
before
lord, on
participating.
that point, my lord, there are decisions.
After becoming successful bidder, he is
My lord,
losing
there are
opportunity.
decisions. This point has been decided by the Honorable High
Possession has
Court,
been
my lord.
handed over. What more
Bank-
he wants?
My lord, bank being the seller cannot deny their responsibility since the
It is-
principle of caveat
It
emptor
is
is
all right, but then you have taken possession now. You go put a gate or a door or whatever it is and take possession of the whole thing. The bank officials are there. If
Already
required.
given, already given.
my
my
lord,
lord.
bank is not showing any demarcation. As we find, my lord,
When you
It is-
submitted your bid, did you notice that it was demarcated or not demarcated?
no, that was not demarcated because my
was
lord,
not.
other erroneous, lordship kindly appreciate, another erroneous notification that was made, my lord.
And you submitted to their jurisdiction. You have paid the money. You have been found to be the highest bidder.
Yes.
Possession is right now with you. Please utilize the property.
Lordship kindly appreciate one thing, my lord. They have given a mere symbolic possession. Direction was given for physical possession. Your lordship knows the physical possession meaning is the property has to be handed over free from any kind of encumbrances, my lord.
No, whether that was mentioned in the advertisement, free from encumbrance.
Yes. No.
Then, if it says that it is an encumbered property and
My
you
lord-
agree to purchase it,
My lord,
what can be done?
my lord, may I place it in this way, my lord? Kindly appreciate. This is the usual notification in the publication of notice by the bank. In spite of that, two honorable high courts had decided that mere as it where is and as it what is will not do. It is the responsibility of the bank to hand over the physical possession to the
Listen, please do not repeat submissions. You have made submission and the court has heard it. I still feel that if you have any difficulty, the bank officials will be there to help you out. But then I do not know what is happening. You have taken possession. There is a gate. You say somebody else
Sale
is coming.
certificate has to also be handed over. Well, let's kindly see only one sentence of page 49. my lord. Kindly see page
whether
49.
there are two cut of 4
Whether they have any
36
case what
they
they
have
submitted.
not made us
Page 49.
understand in respect of the measurement. my
Let's see
lord.
page 49. Kindly see
And
the
my lord,
Penultimate paragraph.
last second paragraph.
Yes.
Section of the scheduled properties and related document up to date EC etc. by
All right, it's all you have issued a sale certificate, two
Yes.
kata, 4 shitaks and
Yes.
something.
Yes.
You measure it and see whether you have handed over the
We have
whatever is
handed
there.
over in its entire.
Measure and see.
We will measure it. No issue.
Yes,
No issue.
please come.
We will measure it.
The petitioner submits that though possession has been handed over to the representative of the petitioner, but the measurement of the land as mentioned in the sale certificate has not been made known. Has not been shown to the petitioner, physically shown. Step. The representative of the petitioner is directed to contact the concerned officer of the bank for taking a spot inspection of the property that has been delivered in terms of the sale certificate. Step. The entire process shall be videographed and be preserved by both the parties. Release a matter for further consideration on 2nd September.
And my lord, in respect of the electricity connection, because I will be prejudiced, my lord. There is
Yes.
no electricity connection. Kindly
There is
observe
no
it.
electricity. Nowadays, 2 months electricity default, it will be disconnected.
No,
How
no,
is
sir. I shall be held
no
responsible.
electricity there? No electricity is there.
It is made clear that any dues prior to the petitioner taking over physical possession of the property, that is on date. When did you take possession?
Let's see, any dues
I-
regarding
I- I-
electricity.
Yes.
Because for property, they have to pay, because as is whatever there is basis.
Fourth of,
Legantine.
You let the petitioner know how much is the due.
It is very much in
and
the
my lord,
document.
I should
Sure.
find, my lord, there
Yes,
is no
not kindly see.
electricity
Kindly
meter.
see.
It might be, my lord, pilfering.
Not see, kindly see.
It
That
might
is
be
why.
pilfering.
That
This
is
my lord,
why
this
I was trying to
this
impress
must
upon the
be, my
court
lord, made clear, my
the
lord.
specific terms of the,
Show me the electricity bill.
not electricity bill, it's the terms and conditions of the auction.
Sir, will you please show what is the electricity due of that premises?
Not see, the electricity bill is not an encumbrance, even the recent judgment of the honorable
Will
court.
you please show what is the bill? Are you aware?
Lord, if there is no electricity, how we will aware?
There is no electricity.
No
My
electricity.
lord, I will show from
No
my
electricity.
videograph, my lord, there are
Videographed it
electricity
was.
and
Lord,
information.
kindly see page 50, after sale, no representation will be considered.
It is made clear that dues.
One of the part of the auction notice.
না এটাকে রাখুন, আপনি লিখুন যে the learned advocate for the bank shall take specific instruction with regard to the electricity meter
Yes.
of the subject premises and any dues of electricity
Okay.
at the said premises.
And my lord, there are, my lord,
Take this photograph back.
there are, my lord, pen drives, if your lordship so desires, there it will be apparent therefrom they are consuming electricity, my lord.
All right.
Nobody is saying
Next.
who is consuming.
My lord, if maybe, my lord, pilfering, I shall be held responsible under subsequent.
Yes.
This, my lord, kindly protection in this respect.
Yes.
Read 51.
I appear on behalf of the petitioner.
Yes.
That is the very marginal amount is, my lord, had been withheld by the authority concerned. Kindly come to page 9. So I have been engaged by the authority concerned.
Regular maintenance of
So
BTL
that amount only 1,93,000 has been withheld by the authority concerned, though I have performed my duty. So now the last occasion, Lordship directed to the
The district magistrate's report was called for. Who is
the
for the state?
subsequent Malada.
Behalf of state in this matter, Lordship.
Yes.
Lordship,
Where
this
is
is
DM's report?
this is the report, my lord, filed by the secretary. I am authorized by the DM, Lordship. Last page is the authority.
What does the report say?
Lordship, the report's fine. If your Lordship kindly turn to
Did
page.
you serve copy?
Lordship,
I have done.
Just now?
Just now, Lordship.
Why?
It is my fault, Lordship. and
My lord, only
I could
one
not
thing
do it
I
within time.
can need to submit before your lordship. The persons who has, my lord, prepared the, my lord, the report, page 20, kindly see.
Yes.
My lord, that report, my lords, these persons, a writ petition has been regarding his, my lord, the appointment, challenge of the appointment of these particular persons. He is, my lord, against that self-help group, my lord. He has prepared a writ petition pending before your lordship. Because of that, my lord, this since we are not the, my lord, this favor child, or I cannot use this language. So now this, my lord, this is the two-fold submission before your lordship. Report, in the name of my lord, the report, I have been harassed after my lord, this the filing this writ petition by these particular persons. Only two-fold submission. Whether the, as per the page 9, kindly see my writ petition. Whether this that engagement which has been made by the authority concerned, whether we have performed the duty or not, that is very vital. Either our engagement has been cancelled, somebody else has been appointed, and plant has been maintained by the some self-help group. So report, my lord, these particular persons, I think, my lord, he has, my lord, given a negative report to the authority. So now my learned friends can say, Amit, whether I am entitled or not, then I can make certain.
Either my appointment engagement should be cancelled or there is no plan. Or somebody else has been engaged, maintain the said plan. That is only my submission. If there must be, my lord, so far my personal knowledge is concerned, if my lord, any special officer is engaged, then it picks at my cost. Then picture will come otherwise. Last.
Yes, the stand of the marketing committee is that the
Yes.
nobody
Lordship, in fact, then we had to engage, if your Lordship kindly turn to page 14. I have also annexed my note sheets also, Lordship, so that Lordship can see day to day that time we have done. As per the instruction wide memo such and such 2023, the undersigned personally visited the site and on inquiry found since January 22 to date that Uttar such and such near never came and the Krishi Bajar name green coconut plantation. Aforesaid SHG is not doing their job, so our own daily wages sweeper Sachan Mahajan Bibi is looking after the plantation as instructed by the office. Then Lordship, next the bottom page, bottom of the same page. As instructed by such and such, undersigned Mathura Krishi Bajar and in inquiry, such and such, the employees of this office said Krishi is found that they have not seen anywhere except Mahajan Bibi in the Krishi Bajar. So Lordship, we have done 2 inquiries, we found this. Now Lordship, what we wanted to more ascertain, after your Lordship passed the order, if your Lordship now come to page 70, we tried to contract them and we requested finally come to the office of the DM. We will try to ascertain because whether my officer is wrong, you are wrong. So on 1st of August, few days back, I called him. Please come, show me because you must have taken plantation saplings from some place or something. Lordship, then DM office called him and the person who done the inspections, those persons are also called. Today what he said, to understand that, we called in the DM office. Then in first also his secretary did not appear before us. Now Lordship, if we found these reports is there.
Why are your representative not going over there?
My lord, there is my lord, the report which has already been, my lord, I have made an application under RTI. I received from the marketing. Now this report has been prepared by Abdul Salam. I personally know. I moved file a writ petition which is pending before your Lordship because of his engagement has been challenged. He is not competent authority to engage. Now kindly see the report is otherwise. I pray before your Lordship, engage any person at my cost. If there is no plantation or no work has been done,
we have
then
done
my
through
lord,
our
I
daily
can,
wages,
my lord, at my cost. I am not paying my lord. They have come with the report. I know this particular person at the instance of his Abdul Salam.
If his appointment is challenged by someone, Lordship,
Malai,
he is my
himself,
government
my lord.
employee. I have to keep on working with him.
RTI report says otherwise. The Dokhin Chobbish Purgana Jela Niyantron Bajar Samiti.
Acha, a report by the
Lordship, Secretary,
South 24 Parganas Regulated Market Committee, affirmed by one Shovik Shah. What is his
Secretary?
Acha, affirmed by the secretary. Is placed on record. Stop. Copy of the same has been served upon the learned advocate representing the petitioner. Stop. The report has been prepared on the basis of an inquiry report prepared by the Mathurapur 1 Krishak Bajar Inspector Group 2.
Group 2.
Abdus Salam.
He is the main.
Lordship, kindly turn to page 13, Lordship. BDO was also there. Under his instruction, everything was happening. Kindly come 13.
I have seen 13.
Yes, Lordship. Then my BDO, my...
Acha, the learned advocate for the petitioner submits that the petitioner who challenged, the petitioner challenged the engagement.
Petitioner self-help group.
Acha, that the self-help group of the petitioner challenged.
Member of the self-help group, my lord, has challenged his appointment.
Acha, self-help group.
Which is pending before your lordship.
A member of the self-help group of the petitioner challenged the engagement of the said Abdus Salam as Inspector -GR2 in the Regulated Market Committee, and the said writ petition is pending consideration. Stuff. The petitioner submits that the report has been deliberately prepared in a negative manner so that the petitioner does not get the relief as claimed.
And no notice at the time of inquiry.
Stop paragraph. The affidavit by the Secretary of the Market Committee contains an inquiry report dated 24th April 2024, which is signed by the Inspector Agril, minimum wages, Mathurapur 1,
And said Abdul Salam.
BLFJE, SSM South 24 Parganas.
Abdul Salam left.
The Block Development Officer Mathurapur 1 and the aforesaid Abdul Salam.
No notice
The Inspector, Group 2. Stop paragraph. According to the petitioner, no notice of spot inspection was served
And no termination.
upon the petitioner prior to inspection of the plantation. Stop paragraph.
May I make one submission, my lord?
Yes.
These are my spot and sudden inspection to find out the thing. So usually we do not give notice because many things upon notice are managed. So Lottie, this is my sudden inspections. From
All right. The district magistrate, being the chairman of the Regulated Market Committee, is directed to cause further spot inspection upon prior notice to the petitioner or any of the representative of the self-help group to ascertain proper facts. Stuff. Let a further report be placed before this court on the adjourned date, released on 8th of September.
Grateful to us.
Grateful, Lordship.
deeply obliged, my lord. I'm deeply obliged.
Lordship, this is my writ petition.
Yes.
Lordship had taken this up on the earlier occasion on 14th July. The petitioner is a senior advocate who had represented the state of West Bengal, but his bills of around 3 crores were outstanding. My lord was pleased to direct that the payment should be made before the returnable date, which is today, but no payment has been received so far.
Nothing.
Nothing, my lord.
An
But,
updated report was directed to be filed disclosing details of the payment.
Yes, my lord. Where my learned friend found the direction of paying, my lord, I have not found.
Yes.
But my lord, initially when the writ petition was found, my lord, claim of around 3 crore and 35 lakhs were being made out of which we have ascertained that we have already paid 98 lakhs and 70,000. And my lord, what has not been paid, we have recorded in our updated report, we have recorded the reasons. My lord, in the meantime, on 21st of July, we have received an updated claim annexing the bills, my lord, which was provided by the learned counsel to us. With regard to that, in the last annexure to this, my lord, this is kindly treated as a supplementary report. The action we have put it together. My lord, we have done a color coding, my lord, for your lordship's kind consideration. Why we have not paid the bills, why we are not in a
Give
position.
a copy to him also.
Now, my lord, if your lordship kindly,
Yes.
as for kindly skips over the first report for the timing, my lord.
All right.
Kindly comes to the second report, which is the colored print.
Mm-hmm.
Well, your lordship will find certain recordings in green. Those
Yes.
have already been paid,
All right.
either partially or in full. Now, my lord, there are certain in red. Now, my lord, in red, my lord, we have found in the first page, serial number 7 and 8, the learned counsel's appearance was not recorded in the orders. My lord, kindly turns over to the next page. Here, my lord, your lordship will find 3 red entries, that is serial number 14, 22 and 23. Here, my lord, we have not found any order sheet uploaded in the portal of the Honorable Supreme Court. My lord, as far as these three are concerned, serial number 14, 22, and 23, if the learned counsel provides us with the order sheet, we can consider these payments. As far as those in orange coding is concerned, my lord, in these we have written to the then standing counsel for a reply whether the learned counsel had appeared or not.
2021, the council will memorize whether somebody was appearing. Can you remember?
We had written to him, my lord, contemporaneously, not now. But my lord, the reply is still awaited because it was the standing counsel who had briefed the learned senior counsel.
All right.
Without, my lord, any recording in our file, we have not found any corresponding permission or approval from our end. So we had written to the standing counsel.
Usually, what is the practice?
My lord, I'll tell you, lordship. My lord, usually, my lord, in the main report, we have given the provision also.
All right.
But if any fees is paid, which is beyond the scale which is prescribed in the manual or subsequent notifications, my lord, a particular threshold is permissible to the LR, which has been extended to 15 lakhs for exigencies. My lord, if there is any payment to be made beyond the prescribed fees, which are beyond the scale, approval of the finance is to be taken. My lord, here, for example, the approved fees of the learned senior counsel was 7 lakhs 5,000. Now, my lord, up to a particular point of time, that is around 2021, your lordship will find in the color coding serial number 18, the learned senior counsel had given us a bill of 7 lakhs 5,000. Then he suddenly enhanced it to 15 lakhs without there being any corresponding my lord, approval from the finance department. Therefore, my lord, your lordship will find in certain entries from serial number 19 onwards, though he raised a bill of 15 lakhs, we have paid him consistently 7 lakhs 5,000 because beyond that the LR did not have any approval of the finance department. My lord, what understanding was there or what permission he has taken from the senior standing counsel there and how the standing counsel asked him to make the bill, my lord, that is not in our file. My lord, without this financial approval, my lord, we cannot make this payment of 8 lakhs extra. Therefore, my lord, some bills we have paid, but my lord, it is not apropos to the bill which we have received. We have paid as in terms of the approval we had. And my lord, there are certain bills in my lord purple, your lordship will find.
Yes.
My lord, those were analogous hearings, my lord, where the state as a matter of policy, my lord, in analogous matters only pays for the first matter and not for the analogous matters because there are sometimes, my lord, before the Honorable Supreme Court mainly, about 21, 22, 25 matters are grouped together, my lord, for the convenience of the Honorable Bench, my lord. My lord, there, my lord, the exchequer is taxed, my lord, quite a lot. But it's a matter of policy, my lord. It has been followed, my lord. Now, my lord, if your lordship kindly comes to the main report, my lord, the provisions and the approvals, my lord, we have mentioned in the second page.
When are you going to follow it up? Awaiting reply from the standing counsel, awaiting reply. When
Well, only those three matters, my lord. There are we have written to the four matters.
Four.
We had written to my lord the then standing counsel. My lord.
Right.
Well, this we can follow up, my lord. With follow.
And is the standing counsel still there as a
No, my lord.
standing?
It has now changed twice.
Then will you get response from the standing counsel who's no longer there?
No, we may not. But
Then
as I said, my lord, it is not like we have written to him now. We have written to him contemporaneously.
Then no follow up.
My lord, the petitioner can take it up with the briefing counselor also, my lord.
Petitioner is not getting the money, and then he's going to take it up with the
petitioner.
This cannot be done.
Petitioner has appeared, my lord, in the brief of the council, standing council.
Who the petitioner defended.
But it is, my lord, as far as those matters, my lord, except those greens are concerned, my lord, we are not in a position to pay because there is serious dispute with regard to those appearances, my lord. Where there is no dispute, we have paid according to the permissible limit.
Lordship, I have two submissions to make. First of all,
Yes.
when the bills were raised, my lord, contemporaneously, they were never returned to me. Even after the bills were raised, I was allotted briefs. I've appeared in the matter.
Exactly.
My lord, in the previous day when the matter was taken up, Lordship would take the previous day's order.
Yes,
At
I have
paragraph
seen
number
that.
5, direction for payment was made.
Yes, I have seen that. Thing is, see, after the council appears, now you say that I am not going to pay your bill is certainly not accepted.
No, my lord, it is both ways, my lord. If your lordship kindly sees, my lord, after my lord, the learned council had raised the bill of 15 lakhs, which was not approved by us.
Settle it out with the council. Otherwise, it will be very difficult.
No, my lord, kindly looks at the other side of it, what my learned friend submitted. that he was still given a brief to appear.
Yes.
But the other way round of this thing is that when the bill raised was of 15 lakhs and the payment was of 7 lakh 5,000, but the learned counsel kept on appearing, my lord, at
No,
that
sir.
payment.
Thing is, you appearing today, payment is made 1 year after. How will the council know
My
how
lord,
much?
not in all cases, my lord. Not in all cases, my lord.
Immediate
Not in all cases.
payments are immediate payments made.
May not be
Then-
immediate. May not be immediate, my lord. May not be
Then you
immediate.
check
But
it.
your lordship, my
You
lord, kindly
cannot say that why did you appear even though you know that
I'll tell you,
half of it will be
kindly
paid.
sees the time difference between, my lord, serial number 19 and serial number 30.
19 and
Serial number 30. 19 is in 21-22 and 30 onwards is 22-23.
Yes.
So, my lord, it's not like, my lord, it's on a day-to-day basis the learned counsel is appearing. And from the list also, your lordship will find that only in certain cases the learned counsel was being briefed.
Not in regular.
As a special counsel,
Whatever may be the
So,
reason.
my lord, at that point of time also, my lord, the learned counsel, my lord, knowing that he will be paid 7 lakh 5,000, he has appeared in the matters.
And you have never intimated.
Yes, we have. Kindly takes page 18.
Page 19. 19th of August 2021.
Yes.
I am directed to inform you that the proposal for enhancement of fees has not been approved.
Has not been approved. This is in 21-22. And then he's appearing in 22-23, 22-23. All bills have been raised for 15 lakhs.
I do not know what transpired between the standing council.
Yes, my lord, that is why we have written to the standing council.
Lordship, that is recorded at page 22, which is my representation.
So is it there?
That is my representation where I have written.
Yes, what have you mentioned?
Lordship kindly takes paragraph 3 of my representation at page 22. I have been
Yes.
charging my fee at a concessional rate at the request of the concerned standing council for the state of West Bengal. My fee for appearance stands at 15 lakh plus conference and clerkage. However, owing to the special request made by Mr. Such and Such, I kept my fee at a consolidated amount of 15 lakh, which included 10 lakh towards my appearance and the rest towards detailed conference and for perusing the brief.
Please settle it out. See, otherwise it will be very not look very nice. The state is served by councils, senior councils, and bills are not being paid. You please speak to the erstwhile standing council, whoever was there, and see. Otherwise, it will be very difficult.
The erstwhile standing council is also named in my representation.
No, there is no dispute with regard to his name.
You please try to solve and see.
My lord, in that case, my lord, kindly, my lord, adjourns it for a fortnight, my lord. I'll ask my client to have a discussion with the petitioner, my lord, in the meantime, so that if at all it can be
Settled.
sorted, my lord.
Yes. Fortnight takes us to 25th. Please come.
Kindly, for the timing, keep the report on record.
Yes, yes. Report by the
By the learned legal remembrancer. This one.
Learned Legal Remembrancer, West Bengal, signed on 22nd July 2025. Is taken on record. Stop. Paragraph. A copy of the same has been handed over to the learned advocate representing the petitioner. Stop. On the prayer of the learned counsel representing the state, hearing of the writ petition stands adjourned till 25th August.
Lordship, may we file a reply to this report?
What is there to reply, will you say?
Lordship,
Are you disputing anything?
Lordship, I will take instruction because some payments they have said they have made.
Check up. In case it is not made, you can always come. No difficulty.
Very well.
25th August. The parties shall in the meantime try to resolve the issue in question.
Grateful.
My writ application, my lord. My lord, in this writ petition, I'm challenging, my lord, a very peculiar situation that has happened. And also at the same time, bias, fraud, and certain extraneous circumstances that I am alleging has taken place, unless they prove otherwise. I was, my lord,
The union, and I have instructions that a necessary party, the rail wheel factory Yelahanka, has not been made a party. And by their own admission in paragraph 13 of their writ petition, they state that the entire subject matter of rejection of the axles by respondent number 3 finds its basis in the objections raised by the rail wheel factory Bangalore. And that rail wheel factory Bangalore has not been made a party.
not a necessary party at all.
They are
Not even a proper party.
They
Not
are-
even a proper party.
They are
All right, let me hear the petitioner.
No, there is an agreement that is executed between me and the respondent number 3, which my learned friend is representing. Based on that agreement, I am supposed
Will you represent respondent number 3 also?
Yes, Your Lordship.
All right.
she was, my lord, on the last occasion
Alright.
appointed by court.
2 also?
Yes, Your Lordship.
1, 2, and 3?
Yes, Your Lordship.
All right.
And Your Lordship, rail wheel factory is supposed
Also-
to be a necessary and proper party.
Very well. He says that
Not a necessary party.
not a necessary party.
Lordship,
You
the
have,
entire basis of the rejection by their own
but then
admission.
since you are there and you'll be representing the said authority, you have all instructions. You can
Your
rely.
Lordship, but the rail wheel factory has to say why they have rejected the axles.
That comes under the union government. I can, if
No, but the union.
decided, I can go and amend it. It's on the appellate side. I can, but it's not a proper or a necessary party. I don't need to, I don't have any privity of contract with.
They are both, Your Lordship, because they are the ones who have rejected it. And
They have
are
not.
The authority.
They have not rejected it.
All right,
I-
let place your case.
Paragraph number 30.
But I
Please,
just
your
placed
case.
my case. madam.
Yes, please.
So there is an agreement that is executed between me and the respondent number 3 for the
Right.
purpose of carrying out certain job works
Hmm.
for box and axles. Now this agreement, well, they are supposed to provide me objects. I'm supposed to convert them. I'm supposed to give it back. Now there are certain third parties, my lord, that the respondent number 3 is functioning with. Now those parties, my lord, have a contract with the respondent number 3. I don't have any privity of contract with them. They are supposed to approve internally or disapprove of whatever I send them. That is between the respondent number 3 and those other third parties. Now, because it's a government of India undertaking, whether there is an approval or disapproval, Lordship is very aware. In fact, your Lordships have held in several judgments, would have to comply with certain, my lord, codes. That is internal. I'm not even on that. Now, when I supply some of these objects that I have carried out as part of job work, they raise certain disputes with respect to the fact that they have not been properly converted, or the job work that I have carried out is not properly done. Till that point, my lord, I don't have any objection with that.
Hmm.
If they want to reject it, they are entitled to reject it.
Hmm.
I would have taken a different course of action if it were rejected.
Hmm.
Now, what had happened was, when I give all these goods to them, the respondent number 3, whoever were the officers at that point in time, because this was public money, they issue a letter to this entity called the Rail Wheel Factory, which they have a relationship with. Lordship will kindly take up page number 73 once. This is what my entire writ petition stands on. So this letter is dated 10th of February 2024.
Yes.
There is an internal communication between the respondent number 3 and the rail wheel factory that she refers to, that I have nothing to do with. Where the respondent number 3 writes, my lord, I'll just read from the second paragraph onwards. For machining operations, only 2 vendors, namely so-and-so, one of them is me, are engaged by MSF, which is the respondent number 3. At initial stage of machining, Mota Coal Company Private Limited has made a 0.5 millimeter step in wheel seat area in place of taper and 45 units of axles. However, all other dimensions were found to be okay. Out of 45 numbers, 18 numbers were dispatched to RWF, Bangalore, after rights inspection. After joint inspection, Vide so-and-so performed...
Yes, thereafter one time relaxation was also requested to be made.
Yes, because public money was at at stake.
Yes.
Now, this letter was issued by my learned friend's client on the 10th of February 2024. Now, without, my lord, there being a response coming to this document, they take my security deposit, encash it. Now, Lordship will now, my lord, kindly take up page number 37 once. This is the agreement, my lord, executed between me and the respondent number 3, which allows them to, my lord, encash the bank deposit, the security deposit, and the bank guarantee. 37, my lord.
Yes.
Lordship will look at 6.2.
Yes.
The value of each forged axle is 74,000. Firm has to submit a material security deposit MSD in the form of a bank guarantee at the rate of rupees 74,000 per number in advance before lifting of the material. Rejection 3% is allowed. However, in case of rejection of more than 3% due to vendor's workmanship, an amount of rupees 74,000 per axle will be recovered from the firm from their submitted MSD, PSD or other pending bills at MSF or any other sister entities. Minimum MSD amount should be rupees 74 lakhs to cover the price of 100 units of forged box and axle. Now, this clause bases itself on the fact that there has to be a precondition. The precondition is rejection. Now, because of this letter that I've shown, my lord, which is at page number 73, the letter of rejection was awaited. Till date, there is no rejection that has come. One fine day, my lord, on the 19th of February 2024, they encashed my bank guarantee without putting me on notice. It is the bank that informs.
The rejection is there from page 73. Rejection is there, but then there is a request for granting relaxation. There is no response to that.
There is no rejection. They have said that they have returned this. There has to be an official communication saying that these goods have been rejected. They are lying with RWF or whatever entity that they have an internal communication with.
Return to MSF for rectification.
Yes, MSF is respondent number 3.
Yes.
So this has not been rejected. This has not been returned to me. Yeah. There is no rejection, or at least there is no document that I have been served with. Today, if my learned friend shows a document where she shows that contemporaneously there was a rejection that had taken place, then my case falls flat on its face. I'll not argue this anymore.
Yes,
I will take my remedy wherever. Now she'll have to prove that that has been served upon me. Now that's number 1. Number 2 is, as on 10th of February 2024, the response from RWF was awaited. Now, what happens within, my lord, the 19th of February, which is a period of 8 days, that they encash my bank guarantee without putting me on notice or giving me the rejection or any ostensible reply from RWF. This is the long and short of my case, madam.
We have written them.
Please wait. Let him make his submissions.
Look, this is the long and short of my submission. Today, if they rejected it, I would have had to go before a civil court and ask for a remedy there for recovery of money. That would have to be decided. But today, there is no rejection.
Is it there any in-house for grievance redressal
not as per the
mechanism mentioned?
Not as per the tender terms, not as per the work order. There is no arbitration or, for that matter, any.
So the civil court is the only remedy that's left.
If I can show, or if I fail to demonstrate that there was a rejection, or if there was a communication pursuant to the 10th of February order, then I would go before a civil court and I'll claim my rights there.
All right. Yes.
Lordship, first of all, the rail wheel factory, I'll tell you, Lordship, why the rail wheel factory is a necessary and proper party. Lordship, by their own admission in their lawyer's letter, Lordship, on page.
No, page 73 has been placed.
Yes,
page 73.
73.
You make a request to the rail wheel factory to grant one-time relaxation.
Absolutely. Absolutely.
Thereafter, you go and encash the bank guarantee.
No, Your Lordship. No, they have been given time and again, they have been issued letters, Your Lordship.
Time and again means 10th February is the communication at page 73.
Yes, Your Lordship. So 10th February is is that communication. Then, Your Lordship, 21st of February 2024, we have an email which we sent to them, Your Lordship, where we say, with reference to the above, it is hereby intimated that 37 lakhs has been recovered by encashing the so-and-so.
Exactly.
That means prior to that, you go and encash it.
Letter of 8th of May 2023, wherein I have said,
Madam, we are speaking of February 24, when there is a request for relaxation.
Yes, Your Lordship.
Within 8 days, what happened that you went and encashed the bank guarantee?
Your Lordship, they time and again we have written to them.
What is this time and again? What is this time and again?
Your Lordship will kindly let me use affidavits.
No, that is something else.
Documents that he has not placed on record.
Maybe, but then the bank guarantee was invoked within a period of 8 days.
Yes.
What made you invoke the bank guarantee without a notice?
There were notices served to him, Your Lordship. Final notice is dated 8th of May 2023, where it has been written to him that this shows reluctant nature of your firm to execute the supply order and it is complete violation of contractual obligations of supply orders, terms and conditions.
That means even after May 23, the metal and steel factory went on to give one time at least.
Time and again, we have given them an opportunity to rectify their defect. They have not done that. And even after that, we kept writing letters to them. We kept telling them that you rectify it, we will refund it to you. Even in my 21st February 2024 letter email, I have said it is intimated that in case the firm rectifies the 50 number access lying at the MSF, then the equivalent forfeited and cashed amount will be refunded.
But they were already directed to file a report.
The factory has to answer, Your Lordship. It is a necessary and proper party, Your Lordship. And there are so many documents that he has not brought on record, Your Lordship, which are important for Your Lordship's adjudication of this matter.
Learned advocate representing the Union of India seeks time to file an affidavit in the matter, disclosing documents which the petitioner allegedly has not annexed in the writ petition. Stop paragraph. The
Lord, may I?
Respondents are directed to file a report by way of affidavit disclosing all facts and figures. Great stuff. The said report shall be prepared and circulated by 29th August. Exception, if any, may be filed by 12th September. Stop. Liberty to mention the matter for hearing. Stop. The fate of the bank guarantee shall depend upon the result of the instant writ petition.
But I'm only praying for Your Lordship to make it returnable. It's a report. They haven't. This is not
Let
going
us
to become a
see.
hearing matter, my Lord. Kindly.
No, report, then exception,
Lordship
then what
makes
will
it
it
returnable.
become?
My Lord, Lordship has understood what is there. Lordship has heard us at length. Kindly, my Lord.
I have given you liberty to mention. Please
No,
mention.
I understand, my Lord, but it'll become very difficult to have it because it'll become a hearing matter at that point in
Yes,
time.
it
Because it's
will
only
be.
a report. It's not going to be an affidavit.
No, report by way of
Yeah,
an
in that case,
affidavit.
my Lord, pray for Your Lordship to, my Lord, include it that they'll secure this amount in the interregnum.
Whatever the fate of the writ petition
No,
will
secure
be,
it
then
with the
they will.
registrar or secure it in a interest-bearing account. At least in the interregnum, they'll secure this amount, my Lord.
No, next. Yes.
On behalf of the petitioner, my lord. By the order dated 26th of June, my lord.
Yes.
My lord was pleased to direct the private respondent to vacate the premises belonging to the
Has the
petitioner.
inspection been
My lord,
conducted?
it has been done, my lord. We have not been, the police has not been handed over the keys.
Who is holding the keys?
The private respondents.
They are there.
They are there, my lord.
All right.
Even my lord.
During the inquiry, my lord, door of the property was open.
Open. All right.
And my lord, last week, my lord, the petitioner has went to the district of the Uttar Dinajpur, my lord. They are residing in their relative house, my lord. If my lord direct, my lord, they will approach to their house within 1 day, my lord.
Yes, go. The report of the inspector in charge, Raiganj Police Station, signed on 6th August 2025, filed in court today, is taken on record. Stop. The report mentions that the police team visited the property on multiple occasions to collect the keys of the house. The private respondents were found absent during each visit, and accordingly, the keys cannot be collected. It was asserted that the private respondents were occupying the said property earlier. The door of the property was found open at the time of inquiry. The matter has been videographed and diarized.
I have the pen drive.
All right, keep it with you. Next, the learned advocate for the petitioner submits that the petitioners are not in a position to stay anywhere else upon payment of rent. Stop. The petitioners intend to return to their property. Stop. It will be open for the petitioners to return to their own property. Stop. The police is directed to render all necessary assistance and cooperation to the petitioners and ensure that the petitioners are able to enter their own property and there is no breach of peace or tranquility in the locale at the time of entry. Stop. The police shall also keep strict vigil to ensure that the life and property of the petitioner is not endangered by the private respondents in any manner whatsoever.
My lord. My lord, unless the private respondent vacate the premises, my lord, it will be not safe for the petitioner to reside in the premises, my lord.
All right, you at least enter. Thereafter, the court will see.
The court had already
Released-
directed to vacate the premises.
Released on 18th of August. You go tomorrow, day after, whenever.
18th of
Next, 18th of August, next Monday.
25, my lord, I am for the petitioner.
Yes.
Finally, my lord, the petitioner received the amount, my lord. Yes.
All right.
Extremely grateful, my lord.
Learned advocate for the petitioners submit that the petitioners have received the amount. Stop. The grievance of the petitioners has been redressed. Stop. The writ petition accordingly stands disposed of.
Grateful, my lord.
All right, with your lordship.
Yes.
My lord, this is that Apollo matter, my lord, that patient who is there, my lord, has
Yes.
been there for a while. My lord, I have been instructed that the Advocate General has said, my lord, to keep the matter after 2 weeks. He's given assurance that the matter will be resolved. So, my lord, if your lordship keeps it after 2 weeks, my lord, as you
Right.
mentioned.
On the submission made on behalf of the petitioners, hearing of the writ petition stands adjourned till 3rd September.
My lord, may I request for the matter to be kept, my lord, as to be mentioned?
Why?
Well,
Mention it. If it is resolved in the meantime, please mention.
I'll do that.
My lord, in 27, I have an rare for my lord for accommodation for the day only.
The day.
For the day only.
Who is your other side?
We are for all of the respondents, my lord, dealer authority.
Yes.
My lord, it was given last chance. My lord, it was
Given last chance. Every day it is being adjourned. Why?
Right.
last chance for my lord.
Today I have been requested to pray for because Mr. Jahan is appearing.
See, somebody else. Every day different advocates are being sent for taking adjournment.
That I don't know. But I'm not at all aware of the fact. Even
In that case, I'll dismiss.
no, my lord.
this
Kindly
time.
don't do that, my lord. Only for the day, my lord.
Ajay, tomorrow has to be mentioned. Alikunta? Not tomorrow, no, day after tomorrow. The matter is being repeatedly adjourned at the instance of the petitioner. Stop. The court is doubtful as to whether the petitioner at all intends to proceed with the matter or not. Stop. To ascertain the intention of the petitioner,
My lord, but my lord,
list the matter on 13th as to be mentioned.
the senior advocate requested me for adjournment sometime ago, my lord, because
All right. To be mentioned.
Lordship, I beg to appear on behalf of the petitioner.
Appearing on behalf of SEBI. Yes.
This is that matter where the bank accounts of the petitioner has been frozen.
Yes,
by the
yes.
SEBI.
What happened?
My lord, on the last occasion, they had taken time to take instructions with
Yes,
regard to the-
passbook first page was given.
Your Lordship, on the last date of hearing, the first page of the passbook was given, Your Lordship. We have handed over to the concerned department in SEBI, Your Lordship. Now, Your Lordship, if I may just take Your Lordship's 5 minutes to explain the matter, the situation.
5 minutes. Why it
We have
cannot
already
be
given it. So, Your Lordship, Section 28 of the SEBI Act gives the power to the recovery officer where to deal with such situation where default has been made and the money needs to be when the money needs to be taken from the petitioner or the defaulter. So in this case, the petitioner, your lordship, the recovery officer, we have submitted that passbook. However, he has
Petitioner
to
is
wait
the
till-
father or the son?
Yes, petitioner
Hello,
is
he is the
director of
father.
company.
Is the father.
The director of the company and the father, your lordship. Now, your lordship, what he needs to do is he needs to make a representation before the recovery officer stating his situation. Because, your lordship, the situation in this matter remains that he needs to pay around around 17 CR needs to be paid by the director, who is the petitioner right now. 17 CR, and out of which 4 CR has been paid. Your lordship, on the first date of hearing, his submission was that he needs to withdraw some money for his medical expenses. So what we spoke to SEBI.
How much is the amount in the account?
Now it depends on the recovery officer, and SEBI cannot comment on it. However, if there's a joint account, only 50% of the amount can be taken out by the director, but subject to all the source of what is the source of fund, and there are requisite documents which will be required by the recovery officer, your lordship. Because if your lordship sees the matter is already going on before another bench which deals with the company, GBC company, where petitioner was the director for 2 years. And that is why when the petitioner approached the SAT challenging the order of the recovery officer, because recovery officer passed the order on 6th May 2016 saying that GBC company needs to pay along with the petitioner jointly and severally around 60 CR.
How much is there in your account?
My lord, in one account there is 75,000. With regard to the other two accounts, those are joint accounts and the primary holder is my son. Now, one is the salary account of my son. Another is a joint account wherein he sends money for my expenses. My lord, both the accounts are maintained by my son. There is not a penny of mine that have been kept in those accounts. And they have been debiting whimsically whatever amounts they can from whenever and wherever they want to. They haven't checked whether
because the money is due from you and you are a joint holder in
now they are saying that,
is
the source of money has to be looked into. Without looking into the source of money, they have been debiting it blindfolded.
Your lordship, source of money has been
And my lord, kindly takes page 75 of my writ petition.
Yes.
My lord, has it?
Yes.
May I read it? It may be recalled that recovery officer, write the subject attachment, proceedings in recovery number such and such, had directed attachment of bank accounts, demand accounts, folio numbers of such and such. Here the name of the petitioner appears at number 5, Sujoy Nundi. In the matter of GVC Enterprise Limited for recovery of sum of rupees 60 crores something, with further interest, all costs, charges and expenses. Whereas notice of demand dated 19/4/2018 has been sent to the defaulter, and the notice of the attachment of bank account and mutual funds dated 7/5/2018 has been issued. Whereas the current liability dues from the defaulter as on date is an amount of rupees 59 crore 95 lakhs something. Now, my lord, kindly takes the report that they have filed. My lord, they say that my liability is 17 crore odd. And here in this order that they have been serving on the bank, that is with regard to the entire 60 crore.
Your
My
lordship,
lord,
if I may, your lordship, this
There
order
are
was
5
challenged by the school.
persons.
We have even placed on record this.
my lord, that is the order that where it says that I have the liability of 17 crore, whereas they are sending this representation to the bank that I have the entire
there are
liability.
5 persons mentioned over there.
Lordship, but
Yes,
that hasn't been segregated.
But howsoever, we have even written in our report, your lordship, that only 17 crore needs to be recovered, your
But
lordship.
this notice, communication to the banks.
How much do you have in your account? Nothing.
Nothing.
75,000.
My lord,
Your lordship, what he needs to do, he needs
my lord, what my situation is that I only deposited some money with the company. The company, in order to secure the amount, my lord, they have made me a director.
Lordship, nothing on merits cannot be, because the SAT order has already achieved the finality, your lordship. It has
The petitioner intends to withdraw certain amount.
My lord, not withdraw, but to operate a bank.
Acha, to operate the bank account. which has been frozen under orders of SEBI. Stop paragraph. According to the petitioner, he needs immediate finance for his medical treatment. Stop paragraph. The petitioner is granted leave to make formal application before the recovery officer, disclosing all facts and figures. Step. The recovery officer shall take steps in the matter in response to the request made by the petitioner. Step. In the writ petition, what is your prayer?
My lord, prayer is for setting aside of this order. That is at page 75.
That cannot be done without hearing. For the interim, let them, you make application, let them pass orders, thereafter it will be seen.
Let that order be placed before this court on the next day.
Let you file your request.
I'll do it within 7 days.
Achha. Let the matter appear in the list for hearing on 7th November 2025.
Oblige, Your Lordship.
My lord, the details of the recovery officer may be supplied to me otherwise.
Give it to him.
Obliged.
I appear for the petitioner, madam.
Yes.
My lord.
Oh, it is that cinema and
Yes, that's the matter, madam.
Tollywood matter.
But your direction has been effective and fruitful to great extent. What I'm told that we could meet both sides, could arrive at a consensus.
All right.
Consensus is a committee would be formed who will decide the respective complaints.
Again, committee.
Yes.
This is the reason the principal secretary was given absolute power to decide it. Why did he?
Difficulty of this, the nature of dispute that we have seen.
No, I have not.
In a particular shooting, how many technical hand would require? Cameraman, how many? Lightman, how many? This is require expertise. These IS officers are not equipped with that. So they
See how many people, the persons who are involved, let them decide. Why will somebody else come and decide as to how many people will be required or not?
They are. No. This is the report, will not.
Copy of the report has not been supplied to us.
No, it will be circulated.
Why not supplied to me either?
Give.
And secondly, my lord, so far as the consensus is concerned, my lord,
open it.
My lord, I am afraid to say, my lord, there was a show of strength during the course of hearing. My lord, there were at least 60 to 70 persons who appeared on behalf of the federation and its affiliates. And yes. My lord, I am aware. Secondly, my lord, most importantly, my lord, whatever may be the committee, my lord, the state or state functionary or a state, my lord, officer, some officer of the responsible officer of the state has to man the committee. But the state cannot shirk its responsibility in this manner. My lord, there was no agreement regarding the constitution of the committee.
Yes. His client's suggestion has been not what Laditran says. He says that committee comprises of eminent persons from fields in the film industry.
My lord, may I just indicate to your lordship, my lord, if only the film personalities are made members of the committee, there will arise conflict of interest. I am afraid to say so. So, my lord, the state office, I mean the secretary of the department should be the chairperson of the committee, whatever may be the committee.
His consensus is something.
No. My lord, we never agreed to that. We never agreed to the constitution.
No, whether they agree or not is something else. The court is not agreeing. The court has reposed faith on the principal secretary. And the court wants whatever to be done, let him do it.
Why? His expertise, knowledge is required.
Well, there is your lordship will find from the statements recorded. I don't know what is there in the report. Statements recorded during the course of hearing. Admittedly, there is a systematic intervention by the federation in every sphere of filmmaking. in every sphere of filmmaking.
Your denial will not do, sir. Please wait. Just wait. A report has been filed. Let it be circulated first. Let them go through it. And thereafter,
Yes.
whatever is to be done will be done. Look, what are all these things? Supporting documents with the report.
We can circulate the report, may I not so die.
Report is a 2-page report.
Yes.
Right. And what are these? 4th of August 20, please find here with the proceedings of the hearing.
Minutes of the meeting, most probably. Minutes of the meeting.
1st of August 2025. Then the Federation of
the minutes of the proceedings.
ঠিক আছে, আমি কি জানি নাকি?
Federation of the Senior Technicians and the Workers of Eastern India
Minutes are
to Mr. Shantanu
made to
Basu.
sign. Copy of the minutes were not supplied to us.
Everything will be supplied. Whatever has been handed up, please give a copy so that they get to know of it and go through it and then come back.
Yes.
হ্যাঁ কবে?
Acha.
আমি তো 2 সপ্তাহ থাকছি না। Go ahead.
Certain documents in a sealed cover along with a report, 2-page report signed by the Principal Secretary, Information and Cultural Affairs Department on 8th August 2025 has been placed before this court. Stop. The same is taken on record. Stop. Let copy of all documents filed in the sealed cover be circulated to all the parties.
No.
Stop.
England.
The parties are directed to revert with necessary instruction. When do I keep it?
Monday, my lord.
After 1st of September.
Why?
1st of September will be too late.
আচ্ছা কি হচ্ছে? My
My lord,
opinion
the
not
1st of September, my lord, we will continue to suffer at the hands of this federation. The state will not make that submission.
Correct.
Mr. Bhattacharya appearing,
No.
Mr. Bhattacharya appearing.
I'm not indispensable. Matter can be to transfer.
You are
On personal ground, I will not be in Calcutta or India rather.
from
14th to 30 August 30. But not, I'll also give a date as Mr. Mujumdar insists on.
Malay, I leave it to your lordship. Malay, it's Mr. Mitro's personal difficulty.
14th, you are leaving
Yes,
at night.
at night.
So 14th will fix
14th,
it.
my lord.
Yeah?
14th.
No, 13th.
14th.
13th.
You want
13th I'll come to court. 13th
Very
I
well,
come to
13th.
court.
13th.
Very well.
What? Yeah, wait, very low list.
13th.
13th.
13th and I'll be here.
Wednesday.
Advance হয়ে গেল।
31.
31, 36 to 45.
Yes.
37. কত?
37
Item number 31.
45.
Pradeep. Item number 31. The report filed in the matter of দেখে নেবেন ওটা কার নামে আছে। হ্যাঁ
6 to
হ্যাঁ
40.
কার নামেতে আছে।
30, Lordship, 36 to
Will
45.
apply in the instant case also. Release the matter on 13th.
6 to 45.
31 and 36 to
45.
45.
29 to 31 and then 36 to 40.
29 to 31 and then 36 to 45. প্রথমেরটাতেই শুধু রিপোর্টটা হয়েছে and this report will be used in the other matters. সেইটাই। All right.
13th, my lord. It shall
Day
appear
after
on
tomorrow.
Day after tomorrow. 42, I think. 42.
32, my lord. May I request your lordship to come to the last order by your lordship? There was a direction upon me
Yes,
to produce the fresh medical report of the patient.
yes.
That is regarding guardianship on the National Trust Act. Elder sister is asking for the custody guardianship of the younger sister who is suffering from schizophrenia. So, my lord, there was a final diagnosis. Kindly seize, my lord. The relevant certificate is at page 4, my lord. It says that therefore it is being declared now that a new disability certificate issued dated 26 July 2022 Srimati Paromita Chatterjee is permanent in nature and there is no need of
requirement of
So
reassessment.
schizophrenia permanent by nature
So what is to be done?
and it is 80% as per the certificate.
Hmm.
Now, my lord, the authority says that under this National Trust Act, the LCC, local committee, does not have the power to deal with the issue of a patient suffering from schizophrenia. It is not mental retardation. Now,
And there
Madras
was-
High Court supports your lordship.
And something was mentioned as to it can recover. There is a possibility of recovery.
Lordship is referring to our last
Last
reports.
report. Yes, yes.
We have filed as many as 2 reports, lordship.
16th May 25,
16th May. We have
DM has mentioned page 3, last paragraph. In future has a chance of getting well. It's an illness and future has a chance of getting well.
last paragraph.
Page 3. See, it is something like this. Page 3, the patient, it starts the patient.
So, lordship, yes. The patient has been given temporary disability certificate.
Right, right.
Mentioning schizophrenia, which implies that the patient is not suffering from mental retardation, but an illness, which in future has a chance of getting well. Now, final report comes today, my lord, the medical certificate. It says permanent by nature. So, my lord, I have checked. My learned friend has is citing one judgment from Madras High Court that schizophrenia patient has been given the custody under the National Trust Act. This Madras High Court judgment, but I don't get any other judgment from any other High Court. Lordship may rely upon this and take measures accordingly. But my lord, so far as schizophrenia, I find from the medical legal dictionary also, it's a mental illness. And mental health acts.
By being so technical, if this lady is left without a care, where will she go?
No, I should not be, lordship. I should not
Isn't
be.
it?
I
Then
should not
there
be.
has to be some alternative.
Lordship. So kindly take care. My lordship may take care. Lordship may, because in this case, custody is not only of the person, but also of the property.
Certainly.
Lordship.
Hmm.
So that makes a difference between the guardianship under Mental Health Care Act and National Trust Act. Now, this Trust Act, lordship may press into service all the sections which are to be taken care of, since it relates to property also. And here the applicant also says that there is a pension issue. Kindly seize, my lord, the writ petition. The elder sister who wants to take custody at page 16, my lord.
Yes.
Page 16 of the writ petition, my lord.
Yes.
Kindly seize the second paragraph. My humble request before you to reappraise the situation. My sister so-and-so diagnosed so-and-so. She is now so-and-so. There is a pending pension matter which requires a legal intervention, but due to her mental condition, she has not been able to do. So, lordship,
Is the patient to get the pension?
I don't know if she's there is
Patient is
a pending pension issue.
he was working.
Father used to be a government employee,
All
central
right.
government employee. Now, by virtue of this mental illness, now she is entitled for
All
the
right,
pension
all right.
because she is not married.
All right. So is she getting it or not getting
No,
it?
no, she's not getting. The legal
All right,
procedure
all
has to
right.
be undertaken.
All right.
For that reason, her sister is praying for this legal guardianship.
Yes.
And Lordship, if I may just point out one thing, my learned senior is saying that this schizophrenia is not covered. He is right, but again, he is wrong because it is covered under multiple disability. Now, for the multiple disability, the statute refers the person with disability act, section I talks about it, and their mental illness is there. Now, what it requires is that it has to be in conjunction with one more disability. That is the requirement, because here there is a blindness, there is low vision, there is hearing impairment and all this. So it is asking that if more than one disability is there, then the legal guardianship or this trust act is applicable. Now, in this particular context, the patient already has 60 or 80% disability with schizophrenia. Now, that logic, whether it pervades or not, that's a question. Because if a person is already intellectually disabled and somebody is required to intervene in that cause, now asking that there has to be more than one set of illness is not a very rational approach. Because mental illness is there, mental retardation is there, locomotor disability is there, and there are a few other illnesses or disabilities are also mentioned. Now, schizophrenia comes under mental illness.
Yes.
But mental illness definition in Mental Health Care Act,
Schizophrenia is not there.
it says no, mental illness means a substantial disorder of thinking, mood, perception, orientation, or memory that grossly impairs judgment, behavior, capacity to recognize reliability or ability to meet the ordinary demands of life, mental condition associated with the abuse of alcohol and drugs, but does not include mental retardation. So mental retardation is the word which is used in National Trust. Mental Health Care Act says that mental illness is something, but it does not include mental retardation.
Under this provision, where is the place for appointment? Where is the scope for appointment of a legal guardian?
Under Mental Health Care Act,
Mental health
Care, substantial difference between the two is that yes, under Section 14, very much she can opt for a nomination of representative, but it is only for a person taking care, but not of the property. Kindly see Section 14. I have checked it up. Section 14. There is a board also. Kindly see Section 14. Read with.
Subsection 3.
Kindly see, His Lordship. Section 14.
Read with.
Read with section, my lord, 80, I think. The board. Lordship, kindly I have given handed over. So she herself can nominate any of her guardians to be her.
Here, the lady is not in a position to take a decision.
So the board will take care of that.
Board. Where is that board?
I'm showing you, Lordship, board.
Right to access mental health care.
Very specific chapter on board, Lord.
Composition of board. And decision with the terms and conditions.
Which section?
In the Mental Health Care Act.
You go through it. Come back.
But it refers only to person of the person, not the
Take up
property.
the law and come back as to how this can be resolved. And you get give a copy to him also. Ashuntu. Report of the District Social Welfare Officer, North 24 Parganas, dated 4th August 25. Enclosing copy of the disability certificate of the petitioner. The petitioner's sister. Clearly mentioning that the patient is declared permanently disabled and there is no need for reassessment of her disability আচ্ছা সার্টিফিকেটের ডেটটা দিন তো 26th July 2025 ঠিক আছে is taken on record. Stop. The parties are directed to come prepared on the issue of appointment of guardian to take care appointment of guardian of a schizophrenic patient who is permanently disabled for taking care of her person and property. ঠিক আছে. When do I keep it?
As per Lordship convenes. Next week,
Next Monday?
in the first half, Lordship, if possible at all.
No, it cannot be assured.
Okay.
18th. List on 18th.
Grateful, Lordship.
May I take back the book, Lord?
Yes, yes, certainly.
Item number 33.
Mala, this is my application, very short matter. There is a direction in last date, they have supplied copy, but since these are illegible, this is my request to my learned friend of the
Has it
representing
been
the authority for the typed copy, my lord. He has not been, maybe he has some problem, my lord.
I'm appearing on behalf of the respondent number 6, my lord.
Type copy given?
No,
I'm handing over the type copy, my
Oh.
lord.
thank you. My
When
lord,
it is over,
disposal, they can have it.
check up. Acha, type copy of the documents sought for by the petitioner have been handed over to the learned advocate representing the petitioner in court today. Stop. The grievance of the petitioner appears to have been redressed. Stop. The writ petition accordingly stands disposed of.
Hey.
Legible, all copies legible. Can you see?
Yes, yes, yes.
The report, Lordship, I am appealing for the respondent number 2. Okay.
Petitioner dismissed. Record your appearance. জানাবাবু হাতটা বাড়িয়ে কাগজগুলো নিন
34.
Yes.
Obliged to Lordship.
In this matter, I was supposed to get the instructions, but the writ petition hasn't been yet served to me.
This was a case where from original
Passport,
side.
I was supposed to get the instructions that criminal case is pending. Your lordship's last order, if your lordship sees, lordship, my learned friend is yet to serve a copy. Let him serve
Why?
a
In the original side, copy was not served?
My lord, copy was served. Only the number which has been given in the appellate side, I have to give that. Otherwise,
Office will allot the case
Yes.
once again.
Now your lordship has engaged me. Now I need that appellate side number, your lordship, nothing else. He needs to give me a
Your lordship,
intimation.
Union of India had
my lord,
filed
Union of
report
India have already
wherein
given number.
several other cases have come out which is against him, wherein he still has not taken NOC in proper format. So anyways, pendency of this writ petition would not help him. He has to obtain, go to the.
Why don't you go before the trial court and obtain orders?
My lord, I will obtain. Your lordship kindly-
Particular case where case records are not available. For that, he has to apply for certified copy, restore the file.
No, but then do you have the case number?
Yes, that case number is provided in our report.
My lord, your
Give
lordship
me the
kindly
number.
hears me, my lord.
Report to that, na?
আমার report লিখতে বলো না।
My lord, kindly take
We
up the
have a
report,
very
my lord.
limited.
Yes, report.
Yes.
What are the case numbers pending against you?
My lord, your lordship kindly takes up from the second paragraph.
Second paragraph.
There is one which is 44 of 17, C10974 of 2013.
Yes.
The other two cases are 14302 of 2011 and 44 of 17. These are the cases. And in Alipur, there is 10752 of 2013 in the next paragraph. Now, my lord kindly takes up your lordship's order where the state has come with another report that there is a separate case pending against me. Now, my lord, after when the submission was made, my lord, your lordship directed the state to produce by way of an affidavit that what are the exact cases.
Affidavit, just a report.
My lord, kindly seize the not the last order, the order prior to that, my lord. My lord, 21st February's order, my lord. Paragraph 2, my lord. Learned advocate representing the state respondent is directed to file a report by way of affidavit disclosing the details and
Why is this not coming? You have a copy of the writ petition.
Your Lordship, first of all, there is in passport, as I have submitted in passport department, the state police has a very limited role. Second, Your Lordship, the nodal of
Give the case numbers which are pending. You do not have.
my lord, I'm handing over 2 sets here and now.
that has
No,
been
no.
given to him, Your
Yeah,
Lordship.
you have given the
Yes,
details.
that report he has just now relied.
That is the report
That
of the Union of
apart,
India.
there is one more.
তোমার রিপোর্টই নেই রেকর্ডে, তুমি কি তো
Your
রিপোর্ট
Lordship,
দিয়েছো?
the Kolkata police can give a report. But Your Lordship, there is no nodal officer as a whole. So this paragraph which my London Finish is referring to, Lordship, I won't, it won't be possible for me to give an affidavit to that effect. Because with the name of the person, it has to be within a particular jurisdiction, Your Lordship.
My lord,
Kolkata police,
at
then
page
it can be
42
Kolkata
of the
police.
writ petition, the
42.
officer has given a report on the basis of which my passport has not been given. Now, in this writ petition, my lord, there is a 144 proceedings. Now, that record is not available even in the PS, my lord.
So the page 42,
Page 42 of the writ
নেই
petition.
এখানে।
ওটা কি করেছিস বলতো আমি?
Warrant number CN 44.
Yes, my lord.
দেখা পড়ো, দেখা।
Police report has been received against you, which is as under.
My lord, 138 of the NI.
Yes,
is
138.
Now, my lord, kindly seize my lord 10974 of 2013. Dated 13th March.
Where is it?
My lord, at the below, my lord. The last one, my lord.
10432.
Yes, my lord. That is
Warrant
7th
number.
March, 107 CRPC, my lord.
Yes.
This is the report to this effect.
This is what the writ
I
petition
cannot
was pending
this
for.
effect. But I cannot, Your Lordship, just now I cannot disclose all details because
You are not required to.
then only to this effect.
Obviously, the cases which you get in your records pending against him, what more will you? If you do not have record, you do not have record.
What he is referring at page 42 is
Yes.
been given by the regional passport office.
On the basis of the police report.
I'm trying to help you.
Very well.
Then he has referred to this warrant number. Your Lordship directs me, I will produce a report with to this warrant number. What is the details? But if your Lordship kindly sees the order that disclosing the details and up to date of criminal cases pending against the petitioner, I can give the details of this, which has been reflected already.
Please come.
At copy
তুমি
basis.
এটাই নিয়ে
Learned advocate representing the state respondents is directed to
নাও, sorry.
produce the police verification report of the petitioner
Page 42,
submitted before the passport authority,
page 50.
disclosing the criminal cases found against the petitioner.
Last page.
Released on 25th.
List of
25th, 2 weeks.
But I have handed over a copy of
yes,
the
I have received the copy.
Sitting here, just went up to court number 18, my lord. Within 1 minute, it got dismissed for default, my lord. I had informed my landed senior friend. He had just gone to.
Somebody was there.
He has gone to.
Let him come. Let him come. Next.
proceedings. A notice has been affixed over the wall, my lord, over the shop concerned. It's in respect of the Highway Act. Now the difficulty is a notice was affixed on Friday. The client has came to me today. The demolition is supposed to be held on tomorrow, my lord. I didn't get a better opportunity to mention it and seek for leave, my lord. I'm humbly seeking for leave so that the matter can be, I can file and affirm tomorrow and the matter can be posted anytime, subject to your convenience. I'll try to satisfy because for the past 50 years, I am over the suit property. There are three.
এটাতে leave দিয়ে দিন. It will appear on Thursday. Serve in the meantime.
I'll serve, my lord. Great.
এটা not today হলো, বুঝতে পেরেছেন তো? যেটা